Symbiosis Law School, Pune, a constituent of Symbiosis International Deemed University. In furtherance of the last 5 years of Symbiosis Law School Pune's work in the Yerwada prison and by the initiative of our Honorable Chancellor, Dr. S.B. Majumdar sir, SLS Pune is proud to host this one-day law and policy e-roundtable discussion with special focus on delayed justice to prisoners in India and issues and challenges surrounding it. The roundtable is specially curated to discuss and deliberate upon various contemporary socio-legal areas along with core issues in prisons across India. It will offer a unique opportunity to the audience to enrich themselves through two plenary sessions involving esteemed resource persons such as academicians, advocates, and law enforcement officers of national repute. For this inaugural ceremony, we have been graced by the presence of our guest of honor, Mr. Srijan Pal Singh, founder of the APJ Abdul Kalam Center in Delhi, Dr. S.B. Majumdar, Chancellor, Symbiosis International Deemed University, and Dr. Shashikala Gurpur, Dean Faculty of Law, Symbiosis International Deemed University, and Director, Symbiosis Law School, Pune. To deliver the welcome address and to introduce the theme of today's roundtable, I would like to call upon Dr. Shashikala Gurpur ma'am. Dr. Gurpur is a Fulbright Scholar, Director, Symbiosis Law School, Pune, and Dean, Symbiosis International Deemed University. She is the former member of the Law Commission of India and awardee of the Karnataka government's annual Kittur Rani Chennamma Award in 2018-19 for her contribution towards gender empowerment. She is a member of Curriculum Development Committee, Bar Council of India, Academic Council of the National Judicial Academy, Bhopal. She is also the member of the IALS Global Law Deans Forum and member of the MCCIA Corporate Legislation Committee for the years 2020 to 22. With more than 26 years of teaching experience and tenures ranging from NLSIU Bangalore to University College Cork, Ireland, Dr. Gurpur is listed as one of the 100 legal luminaries of India by LexisNexis. She has more than 72 scholarly articles and research papers, 2 co-authored books, and 12 book chapters to her credit. She has acted as an advisor to the research project and publication for Asian Network of Women in Communication, sponsored by WACC UK in 1999 to 2004. She is a distinguished member of editorial boards of various reputed journals, such as Journal of IPR by CSIR, Law and Policy Journal, Dublin, Ireland, and Polish Law Review, to name a few. A very warm welcome to you, Ma. I invite you to deliver the welcome address.
Good afternoon, respected Chancellor Sir, who is the founder of Symbiosis, Dr. S.B. Majumdar Sir, our esteemed guest of honor, Mr. Srijan Pal Singh, and all other dignitaries who are here, who are going to adorn our panels in the forthcoming 2 panel discussion rounds. Dear students, dear faculty members, a very warm welcome to each and every one of you. I'm very happy that, like many other pleasant coincidences and very meaningful coincidences, this theme has just surfaced out of the distilled experience of our Honorable Chancellor, Sir, coinciding with our own experience with the Yerwada prison of providing legal aid. Sir was inspired by the early morning message shared by Mr. Srijan Pal Singh, as Sir narrated to me, about this issue of delayed justice as well as innocent prisoners languishing in the prisons of India. So Sir called me and Sir suggested, why not look at this theme and conduct a panel discussion. Now we thought, in order to save the screen time given the online mode, how we can make it a very pithy, substantive, meaningful, and also rendering some kind of impact on the landscape of our justice system in India, entire justice administration. So our esteemed team of faculty members, led by Dr. Atmaram Shelke, Dr. Rupal, and ably assisted by our younger researcher like Aditi Mane, Lasya, Sangramjit Chavan, Ashish Deshpande, quickly were able to come out with this whole concept. We have judge scholars in residence like Justice Shalini Fansalkar Joshi. We have scholars like criminal law scholars like Professor Tiwari of TIS, who is with us now, Arvind Tiwari sir, Subhash Rena sir, former Vice Chancellor, So we were able to look at the 360-degree dimension based on our own work in Erwada prison. I remember when we don't want to name the person. I mean, my own student life, I still remember a 90-year-old lady crying that I never committed that crime of my daughter-in-law's murder, but just get me out. So I remember going to the deputy commissioner and talking to him, who was the head of the legal services committee, that it is going to be infructuous if you let that lady die in the prison. So many times, individual approaches rather than systemic approaches, rather than looking at just numbers, than piercing those numbers and seeing individual case dimension, will be very important when we address the issues of justice. So in Erwada prison as well, we had seen large number of prisoners crowded in the prison, which could have been in a way relieved if we had a way of distinguishing them. With due respect to the justice leaders, I would like to posit before this August gathering that when our work in Yerwada showed that there was a kind of prison court system which started with the initiative of lead justices like Dr. Shalini. We also had in Erwada a situation where in the capacity of 2,000, 3,000 plus prisoners being crowded. It became a major human rights issue all the time when we were addressing them with our manual of human rights compared with the jail manual. And it became more pronounced with the COVID, because jails were the first places where it started swarming in terms of COVID patients. So our own work got halted in last almost 1 year. We have been doing a kind of online linkage with the jail superintendent and trying to intervene. So there couldn't be a better time than this to discuss this issue. So here there are two overlapping, not necessarily synonymous issues. One is what Mr. Sujanpal Singh mentioned to our Honorable Chancellor, sir, the issue of innocent prisoners. Are we empowered to determine who is innocent when there is a kind of rule of law and justice system which goes according to the processes and procedures established by law? Or are we able to, in a way, conduct a kind of deeper investigation into the cases of these prisoners and see how far each of these cases are really going to be dealt in a run-of-the-mill routine fashion, or do they need individual customized approaches to the case? So in that sense, under trial prisoners sometimes end up spending more time in case they were proven guilty by the system, if the punishment were to be handed down to them. Now, this is the irony of our system because of the delays, because of non-classification of cases, because of system not providing for prioritization, because of the cases documentation not being maintained between the court and the prison in a proper manner. I think committed Samaritans like Mr. Sujanpal Singh, equipped with the political sense and technical sense, could be the great contributors to this kind of initiative, which we saw in our students. Our students, I remember our engagement with the prisoners since 2007. First, our institute people took up the issue of foreigner prisoners. We had a Nigerian convict who was not eating for days because he could not eat the food with chilies. And he was crying to us, just get me out of this. I remember Professor Abhijit Vasmatkar coming and narrating to me the findings after the case. Dr. Shelke was also there in the team. Second experience we had was when Bombay High Court made a decision saying that engage the law schools in classifying juvenile justice cases, and some of those prisoners who would have come as underage prisoners, and they might be still there mixed with the adult prisoners. So we were able to get 8 of them out because we engaged with the district court, who were very reluctant to share the documentation, but because of the High Court order, they had to share the documentation. Finally, it was Symbiosis Law School, Pune, which remained till the end in assisting and getting such cases declassified. Our third drive in a fully fledged fashion started with one wonderful faculty joining us again at the instance of our Chancellor, Sir, Mr. Yogesh Dharangutti. He used to lead the prison project in Nirma University. So my dream of running an ongoing prison clinic became real when Yogesh came ahead and he said, ma'am, we can do this, we can do this, we can do that, we can connect our earlier research. So today we have a very structured prison legal aid running in the Yerwada prison, which is more of a prison clinic. We initiate actions in the bare manual of human rights of the prisoners. So there are issues of women prisoners, there are issues of children, there are issues of, children of the prisoners, there are issues of family time for the prisoners, there are issues of nutrition, mental health, there are issues of, let us say, something like individualized approach to these prisoners, regrouping, degrouping. So we engage there. We have very strong support from our management. I acknowledge here Sir's own commitment to justice and human rights all his life in his work. We were only the mouthpiece of that work as a law school in our humble attempt to start it in Yerwada prison. We were able to make a lot of public relations with the government of Maharashtra also. When the Tata Trust came forward to help these under trials, Mr. Srijan Pal, there is a very good initiative which is running there, especially those under trials who were not able to pay, let us say, 500 rupees fine because they're not wanted by the family. They have no way of earning that money. If they have to earn that money in the prison, then they have to work for 2 years. And there was no way of any of us going, paying that money and getting them out and paying the surety. It was here that Tata Trust initiated becoming a kind of supporter. And there also we got involved at the behest of Justice Radhakrishnan, a retired judge of the High Court. So his committee made these recommendations, and TIS and us are involved in Maharashtra government project where various under trial prisoners are being studied. Today's roundtable conference in its 2 sessions is going to bring out this first-hand experience of our team, National Law School, Delhi and Tata Institute in real case studies and in terms of our interventions and best practices. What we see in Maharashtra is a kind of hugely crowded prisons. And although there is a lot of compliance and wonderful prison staff who are professionally trained, in terms of standards, we wouldn't say that all the prisons are following the similar standards. Again, it becomes individual. We have Mr. Pawar, who is so committed, who is a social work and law background person, who is so committed that each one of us, when we go, we get that professional engagement. When any governance, right from the home to country, when it listens to experts, there is a world of difference. When the experts run it and the experts are heard, it always makes a difference. That's what we saw in our experience and engagement with the Yerwada prison. Mr. Srijan Pal Singh, we had our own share of getting 3 prisoners out, and we had to pay personal funds to get their surety money. I remember Sangramjit and Miss Chaitrali, who is a working journalist, who we have been privileged to have her on a payroll as a visiting faculty. She has been the great do-gooder for us by reconciling the issues whenever the prison authorities are unhappy, whenever the government officials are unhappy, when the police are unhappy, and in also creating a very good rapport with the District Legal Aid Services Authority. We have Professor Shirish here, Advocate Sangram here. All of them have strengthened our hands in our avowed mission of human rights and justice in furtherance of our Chancellor's passion. So I welcome each and every one of you to this passion-driven, commitment-driven, mission-driven whole proceedings which are going to unfold in next 2 hours. Welcome one and all.
Thank you, ma'am. Thank you for warmly welcoming our dignitaries and audience and the precise and apt introduction to the theme of delayed justice to prisoners of India and the role that Symbiosis has played in initiating social and legal action in these cases. Thank you very much. Now, to deliver the Chancellor's address, I have the privilege of introducing Professor Dr. S.B. Majumdar, sir, founder and Chancellor of Symbiosis International Deemed University. Dr. Majumdar is the recipient of the Padma Shri in 2005 and the Padma Bhushan Award in 2012. In 2016, Dr. Majumdar, sir, was conferred with D.Lit by Tilak Maharashtra Vidyapeeth. He is also the recipient of the first Dr. APJ Abdul Kalam Memorial Award in 2016. He received the Punya Bhushan Award in 2009, FIE Foundation Puraskar in 2006, Maharashtra Gaurav Puraskar in 2003, Top Management Club Pune's Excellence in Education Award, the Rotary Club of Pune's Service Excellence Recognition Award, to name a few out of his innumerable awards that he has been conferred with. He has published over 50 original research articles in several national and international scientific journals. He has authored several books on life sciences and has contributed over 200 articles on science, education, and youth development. He has also been the chairman of the education wing of FICCI for the year 2015-16. We are honored to have you join us today, sir. A very warm welcome to you.
Thank you and welcome. Thank you to all and welcome all. The guest of honor, Sri Srijan Pal Singh, founder of APJ Abdul Kalam Center, Delhi. Dr. Shashikala Gurpur, a very competent director of SYMBIOSIS Law School. I'm very happy that we have with us, besides Bindu Ronald, Dr. S.C. Raina, Dr. Sunil Chavan will be joining our session next time, first session. And Shashikala told me that Kiran Bedi, Dr. Kiran Bedi will also be joining us. Perhaps Kiran Bedi will be able to tell us something more on this topic because she was chief prisoner of what is it called? Delhi Tihar Jail. And she introduced such beautiful practices there that ultimately she got Magsaysay Award, I believe. Well, friends, I must thank Shashikala for organizing this one-day workshop on delayed justice to prisoners in India. It so happened that I received WhatsApp from Mr. Srijan Singh Paul, and he had written an article in Jagran, and he beautifully and with passion and compassion mentioned some important cases, heart-rending cases about the plight of prisoners across the country, especially in Delhi and Uttar Pradesh. And that, reading that article prompted me to request Dr. Shashikala to see whether we can organize a seminar on this particular topic. You did it very well, and I'm really happy that you have invited so many stalwarts in legal education, legal profession. Mr. S.K. Jain is also going to talk. There are so many stalwarts. Well, friends, as the coincidence should have it, I happened to read a very interesting news article in today's Times of India. I do not know whether Shashikala you have read it, but the chief of Maharashtra prison, Mr. Sunil Ramanand, he has given a direction to all the officers saying that sorry. He says that jails are crowded and therefore avoid arrest in petty crimes, prison chief said. Now, he feels that because of COVID, and you know, sometimes COVID does some justice to our subject. Because of COVID, there is a lot of congestion in the prison, and therefore, officers concerned with arrest should see to it that petty crime I will read it. Maharashtra Additional Director General Prison Sunil Ramanand has requested the State Director General of Police to issue instructions to police personnel across the state to only arrest criminals involved in social serious offences and not those involved in petty crimes in a bid to decongest jails in the state due to the current surge of COVID pandemic. Now, this means that somehow we have realized that prisons are very much congested and they need to be decongested for the simple reason that COVID surge is there. But COVID is not the only reason for this. This news also says that as per latest figures, and this is very important, Statistical, as per latest figures released by the prisons department, 5,411 inmates, including 187 women, are convicts, making for 11% of the total jail population. What is important is to note that as many as 27,944 inmates, including 1,253 women, are the under trials who account for 84% prisoners. Now, this means that under trials are in majority as far as prisons are concerned. And Chancellor Singh will perhaps elaborate on this point that under trials, as you rightly said, they are poor people. They can't afford even small amount to pay for the bills. And personally, I feel, Shashikala, that it's really good that you have constituted professors groups, scholars groups to study the prisons locked in Eroda jail. And I'm happy that you have succeeded in releasing some prisoners. But I feel that as dynamic law college of Symbiosis, you should take active role in saying to it that injustice is caused to under trials and they should be held in, of course, in only deserving cases. I do not want to take much of your time because I want Sergeant Paul Singh to speak more on this topic so that it will help future session to elaborate in detail. Thank you so much and welcome Sergeant Paul Singh for your time and gracing this seminar in spite of several concerns. Thank you.
Thank you, sir. Thank you for your inspiring and encouraging words. Honestly, your vision, your passion and persistence, it encourages and guides us in all our endeavors. Thank you very much. We now have a team from the Community Legal Care Center and Literacy Cell of Symbiosis Law School, Pune, to present the statistical analysis and position paper on the topic for today's roundtable. The team comprises of Advocate Sangramjit Chavan, Ms. Aditi Mane, and Ms. Chetrali Deshmukh. A very warm welcome to you and over to you.
Good afternoon, everyone. I, Aditi Mane and Chaitali Deshmukh are going to present a point position paper presentation on delayed justice to the prisoners in India. To begin with, Community Legal Care and Literacy Cell is an initiative by Honorable S.B. Muzumdar Sir, which was taken forward by Symbiosis Law School. CLCL Cell was mainly established in order to promote and provide free legal aid services to the underprivileged sector of the society. So what exactly a cell does is, we have a major tie-up with Yeroda Central Prison, wherein our legal aid clinic is a setup. Our legal aid clinic plays a proactive role in aiding the prisoners with respect to social issues, setting up of medical camps for jail inmates, emphasizing on rehabilitation, recreational activities, education, and legal awareness is our main propaganda. Also, we have a tie-up with Pune District Legal Service Authority and Crime Investigation Department. We have taken responsibilities and adopted 16 villages and are providing free legal services. And legal awareness camps are also being conducted on a very large scale. As you can see on the slide, that there are some of the snippets of the prison advocacy program under the cell. Photographs displayed on the slide are evidently proof of an internship undertaken by the students at Yeroda Central Prison. On the other hand, aid from SLS is also being provided to the prison for the recreational activities. CLCL cell also provides training to the police officers and I've also taken lawyers and judges training program at Symbiosis Law School, Pune. So it also plays an important role in organizing national, state, and district lok adalats at regular basis. And last but not the least, student interaction during the field visits gives you the holistic picture of the cell. We will now play a 5-minute short video which will help you to understand the CLC's objectives at a larger platform. Also, on the other hand, it gives me an immense pleasure to inform you that the video has won the award of 4th APJ Abdul Kalam International Social Legal Filmmaking Competition 2020, which was organized by Pro Bono India in association with Kamdenu Joshi and Associates, Advocates, Corporate Attorneys, and Legal Consultants. Thank you. Now let's play the video, please.
Can you,
Ashutosh sir, the video is not visible.
can you minimize this and then go for the video maybe?
You'll have to unshare the screen.
Yeah, and then go
reshare
to
it.
the video
and
separately. Yeah.
Hit the option where it says share as a video. Then it'll be smooth.
Is it okay, Amit and Ashutosh? Who is monitoring?
Ma'am, I just play the video.
Yeah, you can play. That's better.
As it is rightly said, that justice delayed is justice denied. The justice system in India is currently dealing with a plethora of pending cases due to lack of adequate judges and infrastructure. With over 3 crore pending cases and an average disposal rate of more than 3 years per case, the road to speedy justice is far ahead. The criminal justice infrastructure in India is overburdened and understaffed, which becomes a major reason for the delay in justice. There are around 1412 prisons in India, with a total capacity of 380,000 prisoners, but the number of inmates in these prisons are around 433,000, which means that the occupancy rate is of 113%. Out of these 433,000 prisoners, around 3 lakh are those who are awaiting their trial and are under pre-trial detention. It has been observed by the Supreme Court of India in Muhammad Shafi vs. State of Jammu and Kashmir that the time spent in the completion of trial procedure far exceeds the actual punishment for the offence for which the person is being tried. This overcrowding has resulted in the deaths of 1,655 prisoners in the jails, with suicide being the major contributor to this number.
The Community Legal Care Center, along with its student cell, Community Legal Care and Literacy Cell of Symbiosis Law School, Pune, established the Symbiosis Legal Aid Program on 9 January 2016.
Symbiosis Law School Pune started this prison project with the Yerwada prison as a learning collaboration as well as sustainable development goal related and human rights related institutional social responsibility initiative. In 2016, we embarked on this project, and in last 2.5 years, there has been lot of learning and lot of intervention, aside from being identified as a collaborator with the High Court's team to look at legal aid to the prisoners.
As on 26 July 2019, the total number of prisoners in Yerwada Central Prison are 5,860, out of which 2,865 are under trial prisoners. Many of these under trials are unrepresented or lack adequate legal representation. This is the major cause for their prolonged trial duration and pre-trial detention. The prison is understaffed and overcrowded, which makes it difficult for the prison administration to facilitate free legal representation for every inmate, which is a statutory requirement in India.
The students of Symbiosis Law School, Pune, come to Yerwada Central Prison for providing legal aid to the inmates. They have helped the inmates by drafting the applications and submitting the documents before the court. They have been genuinely and honestly working for the program. Specifically, male under trial prisoners' legal aid work has been done on a larger scale. Further, medical camps have taken place in both male as well as female prisons. In addition to that, the faculty and the students have taught dance, drama, and even conducted plays in the female prison for their recreational purposes.
Through this program, we, the students who are the budding lawyers, can participate in the process of contributing to the society by helping the prisoners at Yerwada Central Prison, Pune.
Symbiosis Law School gave me the platform to help the under trial prisoners who are not able to afford the lawyers, but Symbiosis Prison program gave them the platform and gave them the legal aid services which is necessary to represent them in the court of law and provide justice.
Our efforts have been recognized by the 14th Finance Commission, which has provided monetary assistance of Rs 2 lakhs for Yerwada program. On 14 September 2016, Herbert Smith Freehills recognized our work and awarded us £2,000, which was utilized for organizing medical camps, legal awareness sessions, distribution of books, water purifiers, and other recreational tools for Yerwada program. The program is running successfully, and the future plans include imparting skill-based training and rehabilitation of the inmates. Symbiosis Law School Pune has been invited by various organizations to replicate the Symbiosis model of the program in other law schools and prisons.
If we win, the award money would be utilized in three folds: 25% towards legal awareness, 25% towards the education of the children, and 50% towards legal representation for under trials.
So, sir, can you please share the screen?
तुमसे जुड़ी कोई भी बात छोटी
Okay, with our wonderful presentation, now we can see the national statistical report. We'll also be seeing the Maharashtra statistics as well as the Pune statistics. Now, as you can see in the screen, the total number of prisoners that we have is 4,78,600. However, when we look at the occupancy rate of the prisons, it's approximately 4,03,739, which basically comes to a conclusion that there is 118% of overcrowding of the prisoners, which tells us that the occupancy rate and the capacity rate is just not matching. So this is where the main problem of overcrowding of prison happens. Now, when we have to look at the under trial prisoners as well, there are approximately 330,000 under trial prisoners out of 478,000, which completely tells us there is a 69% of under trial population lying in the total number of population of prisoners. So if these under trial prisoners basically can be released on non-stringent provisions of bail, basically provisions of parole, basically provisions of probation, so we can come to a conclusion that such a large number can actually come down and the percentage of overcrowding of the prisons can actually fall down. So can we please move on to the next slide? Now, this graphical representation of data talks about the under trial prisoners that have been specifically suspected under the special and local laws. So as we can see on this screen, these are very petty offenses like the Indian Railways Act, the crimes against SC/ST. So these provisions can, these prisoners basically can be released on bail provisions, can be released on parole provisions, can be released on probation as well. And the benefit of plea bargaining actually can be given to them. If this happens, then there'll be 63% of under trial prisoners that be lesser in the jail, which ultimately leads to overcrowding of prisoners problem being solved. So can we go on to the next slide? Now, looking at the national statistics, we come to the Maharashtra statistics, which completely talks about the occupancy rate being high as 152.7%, which tells us that the prison of Maharashtra are being overburdened by 12,700 extra prisoners. So now, in this also big population of 36,798 prisoners, we see that there is 27,557 under trial prisoners, which equals to 74% population being under trial prisoners. Again, if we minus these under trial prisoners from the main occupancy or main total prisoners, we come to a population of 23,878 prisoners that we left in the prison, ultimately solving the problem of the overburden versus the capacity ratio, coming down from 152% to 99%. Now, this report has been taken from the Commonwealth Commonwealth Human Rights Initiative report of 2020. So can we move on to the next slide? The next slide as well tells us about the occupancy rate. We see that the prison statistics of India 2019 talk about 152.7 as percentage as the occupancy rate. Our April 2020 stats talk about 150, and our June 2020 stats talk about 118.4% of occupancy rate, which is still higher in comparison to what it really should be. Can we move on to the next slide? Now, after seeing national statistics, Maharashtra statistics, we come to the Pune statistics. Now, as we've already seen in the video that we have a tie-up with the Yerwada Central Prison of Pune. So we can actually see on the screen that Yerwada Central Prison is actually overburdened by 2 to 3.23%, which actually tells us there is 3,230 extra prisoners lying in the Yerwada Central Prison, which again tells us there's a lot of overburdening of prisoners happening inside. Next slide. Now, this slide basically tells us that there is 15% of population within the under trials which are languishing in the jails for the crimes that are below 7 years. So even if these prisoners can be released on some provisions or can be given the help of legal aid provisions, it will be great usage to reduce the population to at least by 32%. Can we move on to the next slide? Now, there was also a case study that we had wherein a under trial prisoner was held by the CLCC cell Pune, and that actually will be talked about by my colleague.
So far, with regards to the emphasis on the under trial prisoner is concerned, SLSP is very proactive working in providing legal aid to the prisoners of the Yerwada Central Prison. One such example is the case study that we handled of a laborer who was 34 years under trial prisoner who came to know post his arrest during his medical examination that he was suffering from HIV positive. He was arrested by the railway police for stealing railway property goods worth of rupees 480 from the platform. He was languishing in the jail for last 5 months without being produced before the court for his trial, and his health was getting deteriorated after he learned about HIV positive, as well as which also led to a skin fungal disease, which led to a mental depression too. This last wish was to see his newly born baby at his native place. After getting to know from the prison authority, we understood that Mr. A did not have any legal assistant, and based on these circumstances and the fact that we collected from the prison, the cell decided to provide him legal assistance under the guidance of our director and dean, Dr. Sashikala Gurpur ma'am. We, with the help of our in-house lawyers, experts, faculty in the subject, a student, we proceeded with the case. Initially, we approached to the court for his bail fee, but due to no relative and lack of documents pertaining to sureties, we planned for trial. And later on, for 4 such occasions, the police did not produce him before the court. Post a constant follow-up with the official, he was finally produced before the court and he was convicted for 3 months imprisonment. But after further, he was released after being convicted because he had already served the imprisonment. Later, with help of our in-house counselor, we counseled him and he was sent to his hometown, which all the arrangement was done by us. So, based on this case, what we observed that a prisoner who was mere stealing a property of rupees 450 was languishing in jail for a period of 5 months without being produced, which being as one of an apprehension to this. Sir, can you change the slide, please? Which bring us to an apprehension that there might be so many other with different problems who might be behind the bars for more than months or year. Which brings us to the next slide, which clearly show the issue that are faced by under trial prisoners, and you can clearly see the screen that the issue mentioned are self-explanatory, like indiscrimination arrest, detained in bailable cases owing to property, and other cases. And sir, please move on to next slide, please. To tackle this issue, we have certain recommendation which we had already laid down under the recent research work conducted by us under the Criminal Justice Reform Project undertaken by us along with the Home Affairs Ministry Department, in which we have found out few recommendations. Those are below: fast track courts, keep a system or each prisoners are facing information system to keep a track on the case status, alert notification system on e-courts portal, re-evaluating the provision related to arrest, need to reduce the stringent in granting bail, even emphasis of community services, conduct frequent video conferencing and matter related to bail, prioritize mental health, rehabilitations, experts rehabilitations to be appointed in the prison, recreation activities to be organized, as well as motivation talks. So with this, our recommendation cited on the slide, we now feel that this point position presentation has given everyone a brief overview of the prison statistic at the national, state, and the district level. Thank you.
Thank you. Thank you to the CLCL team for presenting those very revealing statistics and making due recommendations regarding the pertinent issues surrounding delays in justice. Thank you very much. Now, to deliver the guest of honor's address, it is my privilege to introduce our guest of honor, Mr. Srijan Pal Singh, founder of the APJ Abdul Kalam Center, Delhi. An IIM gold medalist, Mr. Srijan Pal Singh is an author, public speaker, education innovator, and social entrepreneur. He has worked as advisor to Dr. APJ Abdul Kalam, the 11th President of India. He was engaged in promoting various assignments such as What Can I Give movement, energy independence for the nation, nuclear and space missions, and providing urban amenities to rural areas. He has co-authored books with Dr. Kalam titled Target 3 Billion, Reignited Scientific Pathways to a Brighter Future and Advantage India from Challenge to Opportunity. He's a member for innovations on Maharashtra Water Resource Regulatory Authority. He was also appointed as a mentor to the Uttar Pradesh State Startup Policy in 2016, a fund of 10 billion rupees dedicated to promoting entrepreneurship in India's largest state. In 2019, he was awarded the LMA Leadership Award for Innovations by the Lucknow Management Association. It is an honor, sir, to have you at this roundtable today. A very warm welcome to you.
Thank you, Nasya. And it's an absolute privilege that I'm here. And first of all, let me thank Honorable Dr. S.B. Majumdarji, who is a friend and a guide and a teacher. And I am very pleasantly surprised that one article I sent you, and you have created a movement out of it. So I think that positivity and that compassion, kindness is something which I think is absolutely fabulous and something for all of us to learn from. Because I didn't expect that this will happen out of that one article I sent. So I'm very, very grateful to you. And I'm also not just grateful on my personal capacity, but also I think the issue is extremely important for the country because it's very easy to treat a person who is serving jail term or has been arrested as somebody who's condemned from society. And it's very easy to bucket them in that sort of a British era hangover. but to stand up for the cause of the human dignity of everyone, regardless of whether the person is convicted or indicted or arrested, is something which is truly compassionate. I'm also very happy to know all the wonderful initiatives which are being led under Dr. Shashikala and her team, very young team. And the presentation was very enlightening. I think that research is extremely important. And I noticed a few points actually. It is a learning, seeing that presentation. One of the points I noticed was, and I would like to, the team might like to actually evaluate why. In the past 9 years, I saw the number of people under trial has gone up by 33%. I just saw in the graph. What happened? Because the previous 9 years, no, nothing. It was more or less stable. And then suddenly the graph spikes. So one needs to find out why is it that this sudden spike, which is only a increasing trend, is happening, because it's extremely worrisome. I also noticed that, and this is something which is a stated fact, many places has been stated, is the fact that nearly 2/3 of the prisoners under trial are for narcotics and liquor-related crimes. If I look at the numbers in US, which is a country neck deep in opioid crisis and drug crisis and cartels, even in US, the number of people in federal prisons is 47% for narcotics, and in state prisons, 15%. Across UK and EU, the number is about 25 to 30%. So what makes India, either India is a country way too deep in narcotics and we don't know about it, or there's something terribly wrong in the way these people are being caught. And one needs to, I know some of the things which I'll say does not apply to everybody. So let me just put that, because a lot of things I'll say. So I know there are people from all walks of society, but I'm talking about specific cases, and that does not generalize anybody. But one has to find out, why is it that the narcotics cases in India are nearly 2/3? And this is astoundingly high. One should do a comparison, cross-sectional comparison with other countries, and figure out what is going wrong. So a good way to do that would be to actually go and interview some people and find out their economic profile also. Many a times, this is also, it's not very difficult to accuse someone of, a substance. You put substance in them and, just put substance on them and they're arrested. And the prison term is minimum 10 years for possessing or selling drugs. So one has to find out with an open mind, and I think we need to stop defending our old system if something new has to be realized. Sir, I think the issue is on 3 fronts. In fact, you covered one of the words which I think defines everything: compassion. The issue is about compassion towards a fellow human being. And the issue is about jurisprudence, basic principles, is that one has to protect the innocent. And that is the number one priority of any legal system. Before you punish the guilty, you have to protect the innocent. I think that basic jurisprudence is something which we need to apply in this entire case of delayed justice. I think there are 4 issues which we need to cover. And I will talk about the issues, and I'll also talk about the solutions. I think that is extremely important. And the third thing I want to talk about is some of the experiences which I got, because after I wrote that article, a lot of people met me. In fact, one of them was the person who I mentioned in the first line of my article, which was Vishnu Tiwari, the person who spent 20 years in prison. I think there are 4 issues. First is that there are innocents which are being punished. There are people in jails under trial, and a lot of them at the end of the trial end up being innocent. And so that's number 1. I think that is your first priority to handle. Number 2 are people who are guilty, who have done something wrong, but the punishment they are receiving is far higher than what they should receive. And I think that is also equally important, that people are not over-punished for what they are getting. So the sentence cannot be more than what they have done as a crime. Third thing is that there are innocents and guilty, both, who are spending time in prisons. And it's about the condition of their life, their human life condition, regardless of whether the person is innocent or guilty, because he's spending time in jail. And the fourth thing I want to raise, and I will talk about it, there's a product which we're designing for it. And it's about those people who are guilty of what they were saying, minor offenses, and who we don't need to send to jail. Jail is not the only thing you can you can reprimand a person for. I mean, that's not the last and the only thing which you need to do. I think jail should be the last place you should send a person who you think has done something wrong. There should be steps of what you could do more than before you snatch his freedom and put him in jail. Jail is not a great place to live. It's not a great mental health process. And I feel that if we could do something more constructive for smaller offenses, it will be better. I'll talk about it. So essentially, what I wanted to talk about is, again, the article which I wrote was there, where I talked about this. The trigger point was a person called Vishnu Tiwari, Allahabad High Court. Vishnu Tiwari spent about 20 years in Agra jail for a crime he was accused of included both the SC/ST Act and the Crime Against Women Act. And the Allahabad High Court declared Vishnu Tiwari innocent of the charge of rape, and then he was let go. And after 20 years of already spending time in jail. Now, Vishnu Tiwari, in the time of 20 years, when he started off, he was 22 years old. And when he got off and I met him, he was a 43-year-old man. And he had lost his entire youth in the process. He told me how he met his mother only once. And he described in detail how he saw his mother for the only time he saw after he was jailed. And how she had bent. And he's saying she was a tall woman and she could not walk straight when I saw her. And I said, "You'd never come again to see me because I can't bear it." And he told me how he did not get the news of how his mother passed away and when, and his father passed away and when, and his brother passed away and when. And he said, "I came out and the world had just shifted. It was like everything changed. I had nobody." I think, and Vishnu Tiwari, the problem is he's not alone. And that's something which one has to point out. India is a country where somebody has spent 45 years in jail for accusation of a knife attack, which at best could be a 3-year penalty. India has been seeing cases where somebody has been in jail because authorities lost his paper. So he spent 40 years in jail. So that is the problem. And as the presentation was pointing out, nearly 75% of the prisoners are essentially awaiting trial. And they're awaiting trial. They'll keep awaiting trial for years and years, and they will never get out. And the bulk of these people are poor people. The rich people in this country will afford a lawyer and get at least, they will be out of prison. They'll be out of prison and they'll contest their case. But it's only the poor people who disproportionately suffer. 70% of them are the people under trial are illiterate, barely literate. So that is about till class 10. And 70%, an equal percentage, are from SC/ST and backward communities, which highlights that it's disproportionately is the poor person who's suffering by this entire thing of delayed justice and, in a sense, or even guilty, being put into jail for long terms. So now, in fact, NHRC, the National Human Rights Commission, talks about in its own website, it talks about how there was a process in Tihar jail, I think, where inmates were allowed, they wanted to release the prisoners because of the overcrowding, as you were mentioning in Yerwada as well. But most of them had nobody. Nobody was coming up to give, the sureties. So there's no family which will turn up. They don't have money themselves, and no authority. And I'm very glad that CLCL, you had gathered your own personal investments and done something about it. But imagine this scale is so huge that how would you do it on a consistent manner? Like lakhs of prisoners need this. So the sureties, nobody came up for the sureties. Nobody turned up to pay for them. There's no family which wants to be associated with them anymore. And they just left. So they could not get out, even if they had the provision to be released. So what can we do is the question. And that is something important. And it's a mix of administrative reforms, legislative reforms, judicial reforms, and technology, and also civil society, the kind of work which you're doing. So first is a very intuitive thing to do. First thing is that there should be an upper limit on the duration for which a state can keep a person in jail without any conviction. So, and of course, you can calibrate it to the severity of crime, but it cannot be infinite. So at some point, you have to say that, depending on what crime the person has been accused of, this is the upper cap you can keep him while he's under trial. Because then it's the responsibility of the state to ensure that the person gets a trial and gets a verdict. And you can't keep him infinitely just by a delayed justice system. So that is number one. You should have an upper cap on this thing. And this is obviously more of a legislative reform. The second thing is that, and this is something which is a little touchy topic. See, a lot of times and I know a lot of people, so I can talk from experience, is that a lot of time arrest is used as a tool of oppression, and especially happens in the bottom economic stratum of the society, where people could be arrested for anything, literally. And you could plant things on them, you could plant cases on them, and they don't have the money to contest the accusation charges which they're levied upon. Often the family also kind of stops supporting them. So what do we do about it? Now, at the same time, there are people who commit crimes and they need to be arrested. So you can't really have a complete 180-degree shift. So what I suggested was that you need to have a tracking system to analyze the data of law enforcement bodies, say police, and personnel based on how many accused prisoners by them eventually turned out to be innocent. So one needs to figure out that when a policeman arrests somebody, at the end of the day, what happened to that person, whether the person turned out to be innocent or did the person turn out to be guilty. Based on that, you need to keep a tracking of the efficiency of the law enforcement authority. And those law enforcement authorities which misuse their power, and it will come out by this, suppose somebody is really, everybody they are arresting are turning out to be innocent. And if they do that, then that should be dealt with. I think it's important to do that. And one needs to have, and one of the administrative reforms I've been pushing again and again is putting some kind of performance measurement matrix to our administrative services, whether it's IAS, IPS, or even the state services. One has to put some kind of a benchmark. What do you measure them against? So that is something which has to be done. Third is that the state must own up to its responsibility. Lives are ruined. I mean, look at Vishnu Tiwari, 20 years. He started off his life as a 20-year-old boy who knew how to do Zari ka kaam. And he said that back then in 2000, he was earning close to 400, 500 rupees a day. And he said, I went to jail, and obviously nobody does that work in jail. So he said, the work I was doing in jail, I was getting 30 rupees a day. And that too, and I'll talk about the conditions of the jail in the last section of my talk. But state has to own up to the responsibility of having ruined lives. It's important. I think that's where compassion truly comes in, because when you accept your fault, that is the most compassionate thing you can do, and do something about some things which have gone wrong. I think people like Vishnu Tiwari and many more like him deserve not just a sincere apology, they also deserve a compensation. And I know the Supreme Court does not agree with that. It has passed a judgment saying that it's a bad precedence. But I don't think it's a bad precedence at all. I think it has to be reviewed, and if it has to go through a legislative route, it should go there. Because it's a direct violation of the Article 21, which is the right to life and liberty, and Article 32, which is the right to constitutional remedies. And these are fundamental rights. And we are not alone in doing that. US has the system, UK has it, Germany has it, many more countries have it. They have enacted laws where the state will have to compensate for a person for a miscarriage of justice. In 2019 case of the US court, where they gave 1.5 million to Richard Phillip, who spent 46 years in jail for a crime he never committed, is a case fact on that. I think we need to pick those stories and do something about compensating those who have lost their lives, because they have nothing to go. There's nothing to lean back on. The fourth thing which we need to do is that we need to make our judicial system as much as possible. And I'm positive that we can do a lot. I'm also realistic that we cannot completely do it, but we have to make as much as possible agnostic to economic status of the convict. So that's how the judicial system would work. If an accused cannot afford bail, as you were talking about the sureties, then the state must provide financial support, or even a loan to him. A soft loan could be provided to him to get a bail. So if you can't give money, then at least loan money. There should be a provision for that. Maybe we should bring that as a part of our banking system then. And poverty cannot be a reason for remaining to be jailed when those who can afford can get out, and those who cannot afford that little surety money cannot. The state needs to benchmark the performance of the lawyers which are provided under legal aid. Now, you are doing a legal aid, and the state is supposed to provide legal aid to the people who cannot defend themselves, who can't hire a lawyer. I think the legal aid in many states, it's not something which people take seriously. The lawyers do not take it seriously. And I think the legal aid quality provided under Article 39A, which is equal justice and free legal aid of the Constitution, has to be, again, put under some benchmark. They don't have zeal to perform in many cases. Now, some of them are very compassionate, so that's okay. But the others were not. And performance of such legal aid, which is a taxpayer-funded lawyer, to somebody who is poor, must be openly available. And this, when these lawyers apply for, maybe promotion as a High Court justice, these things should be accounted for. Last, in fact, the fifth point which I want to bring about is, and then I'll bring one more point after this, is the fact that I think technology can do wonders. We are working on a little device, and we have, in fact, we've done it, a prototype, and we have applied for a patent on that as well. It's a small device which connects to a GPS, okay? And it's like it can be a bracelet or an anklet. And you clasp it, it covers a person, doesn't look from outside, it's non-intrusive, it doesn't look bad. If you put it on your ankle, nobody will notice it. And this thing has a GPS, sort of a little, like a mobile chip is there. And it can't be opened. If you open it, then there's an alarm system and your location is instantly shared, and it could be a legal offense to do that. But people who are accused of small crimes, you don't need to jail them. You can actually using technology, you could jail them in the sense you could track their location. They can move around. If you don't want them to go a particular location, you can obviously map them on a technological, sort of a map, because you'll get the GPS coordinates and you can create this thing. And many of those offenders which you're talking about could easily be given this device, forced to put on this device. And as long as they put on the device, they don't need to be jailed. You arrest a person when you think he's going to interfere with the legal proceeding of the person, or he's going to harm somebody who has accused him of. And you can track his location and you can figure out where the person is going. You can geofence him. Geofencing is a tool available, which is readily available. And we should do something. Technology can do a lot of work. And the last thing which I was telling in the beginning was that one needs to give up this whole idea that jail is the only and ultimate reform or a center to punish people. In many countries, there is a provision of mandatory social work, which is a valid sentence for minor offenses. In US, there have been cases where actresses who are possessing small amounts of drug have been sentenced to a community service. Now, for example, look at what happened in the recent COVID issue. A lot of people have gone to jail for not wearing masks in public. Does it make sense? Does it make sense to put a person in an overcrowded jail, which is 120% overcrowded, or in case of Yerwada, 200% overcrowded, to put a person in jail for not wearing a mask? Or that 480 rupee theft, which you were mentioning in that case, does it make sense at all? Does it make sense to put people in jail for social media posts? I mean, if you want them to not make any more social media posts, just block their internet access. That's what you could do. And these provisions are available. You could geofence them. They can't go out of their home if you want. You can even home jail people using technology. They'll never get out of their home. If they get out, you'll get an alarm. So it's not very difficult to do that. And you don't even need to jail them. I think a great positive sentence could be that people could be given community service. It's a positive thing. People will also, the one who was guilty would also think that kuch acha kiya, we've done something good. And it's a positive reinforcement of an idea of national service, which you could do rather than jailing people. So young people are being jailed for social media posts. Makes no sense to me. So those were the things which I wanted to, as part of the solution. And then there is a whole issue of the condition of people in jail. I think a report on that would be extremely important, because you are dealing with, and you have to look at more than one jail sample for that to happen. Because from what I've heard, and these are mostly Northern Indian jails which I'm talking about, there is a rampant issue of the living conditions of people in jail. Now, there is a payment which is given to jail inmates for the day-long work which they do. It is not given as cash payment, it is given as a coupon. Now, different jails have different rates at payments are made. And these payments do not even match the Manrega payments. The Manrega mandates, depending on the state, 200 se 250 rupees, 200 to 250 rupees a day of work. Jail inmates don't get that much. Why? Why is the jail inmates' work less valuable than if he were to work with a minimum guaranteed employment outside? Number one. Number two, there is something which is called a jail canteen. One has to do the audit of pricing in this canteen. The inflation in jail canteens in many of the jails, which I have worked with, and again, I don't have an exhaustive sample, the ones which I have done, the inflation compared to the regular market is anywhere between 100 to 300, 400%. So, जो चीज 1 रुपए की बाहर मिलती है, वो 4 रुपए की वहां मिलती है. And that money is paid by coupons, which anyways is devalued. So you get underpaid and you pay everything more. For everything, you have to pay more. The whole nexus of corruption which runs in these jail canteens has to be audited and has to be brought out and has to be destroyed. Because what is happening is that the regular quality of life goes down. Many jail inmates are then forced to buy items from this jail canteen, cook some of the things on themselves so that there's some kind of a better food. And their entire day's work goes into just buying basic vegetables, and that cycle goes on. And nobody talks about it. Why should a jail inmate for a day-long work not get as much as a Manrega worker does? Number one. Why should there be inflation compared to the usual market rates? The bahar rate hai, that should be the rate inside. In fact, it should be cheaper because you're buying in bulk. Number three, there is an issue of mental health. There's also an issue of physical health. So I've been told in jails, many of the jails now, that there is, if a person gets tuberculosis, for instance, and which this kind of food, it's likely that a person will get tuberculosis. In many cases, what has happened is that when a person gets tuberculosis, a prisoner, then there is a provision for payment for milk and I think some nuts, because the person needs a lot of protein. Even that is siphoned off. So there is basically, there's an incentive for giving bad food to prisoners so that they could buy things from canteen. And if they get sick, you make even more money because then you get an extra payment for milk and nuts, which can be siphoned off. So I think there has to be benchmark jails. Now, there would be some wonderful jails in India which are operating transparently. We should make them as benchmark cases and then apply those benchmarks on the standard should be applied across India. I think if you do that, then I think the condition of living would improve. Jails are not there to torture people. Jails are there to reform people. That premise has to be there. They're not torture chambers. Sazai kala pani nahi hai. It's not a British hangover ki kala pani de diya kisi ko and you torture them and you torture them enough so that they die or they go mentally, they become unsound. But the idea is to reform them. People in jail are humans. Many of them are innocent humans, and those innocent humans actually have a better, because they are being punished for something which they have not done. They actually have a chance to, they should have a chance to live some compensatory life. So one should, I think, do that. And with that, I think, these were some of the suggestions which I thought we could bring about now. Of course, whatever I said does not apply to everyone. I don't want to paint every jail with the same brush, but there are some jail issues which have to be highlighted. And if you do not, and if you just say that we're going to ignore them, we'll never improve anything. Introspection of one's own problems is the beginning of a reform. And I think we need to introspect, we need to acknowledge things have gone wrong, and that will be the beginning of improving things. Thank you for giving me this time and opportunity to talk to such, I'm seeing a wonderful audience. I'm seeing people from all walks, lawyers, police people, and there are social workers. I'm absolutely thrilled to be with all of you and happy to take, participate further on this. So thank you, Dr. Mujumdar-ji. Thank you, Dr. Shashikala-ji.
Thank you, sir. Thank you for sharing your keen insights into the justice system in India, the idea of classification of the inmates requiring differing equitable treatment, and your reflections on the statistics that have been presented by the CLCL team and your innovative reform recommendations. They're very thought-provoking. So thank you very much, sir. Now, to deliver the vote of thanks for the inaugural ceremony, I would like to invite Dr. Bindu Ronald, Deputy Director, Academic Symbiosis Law School, Pune.
Thank you very much, Professor Lasya. Symbiosis Law School is today organizing this round table discussion on delayed justice to prisoners in India, issues and challenges, an extremely important and pertinent topic which aims to highlight the issues of inmates who are languishing in jails of India and to propose recommendations in the form of an outcome document. As we come to the end of the inaugural session, it is my privilege to propose the vote of thanks. There are many who have to be thanked for making this roundtable possible. I take this opportunity to first of all thank our guest of honor, Mr. Shrijan Pal Singh, founder of APJ Abdul Kalam Center, Delhi, and for accepting our invitation to grace the inaugural function as the guest of honor. Your work, your initiatives, and your writings are an inspiration to many. Thank you very much, sir, for addressing the audience. The words and the experiences that you shared will surely provide incentive to many to work in different ways for those who are voiceless, whose voices are muffled behind the prison walls. We also look forward to hearing you during the 2 plenary sessions that will follow this inaugural session. I also thank all our esteemed expert guests who will be speaking during the plenary session 1 and plenary session 2 for agreeing to be part of this roundtable discussion in spite of their very busy schedules. We look forward to hearing from Justice Shalini Phansalkar ma'am, Dr. Kiran Bedi, Mr. Sunil Chauhan, Dr. S.E. Raina, Dr. Arvind Tiwari, Mr. Shrijan Pal Singh, Dr. Anirban Chakrabarti, Dr. Bhushan Kumar Upadhyay, Advocate S.K. Jain, Dr. Harish Shetty, and Ms. Monica Dhawan. I take this opportunity to thank Dr. S.B. Mujumdar, sir, Chancellor, Symbiosis International University, for being there for the law school always. I must place on record that this roundtable is actually the idea of Mujumdar, sir. Sir, your vision, your guidance that is there for us at every step has actually taken the law school ahead. Your empathy and compassion motivates us, sir, and your presence here today gives us the encouragement that is unparalleled. I also thank Dr. Vidya Yeravdekar, Pro-Chancellor, Symbiosis International University, and Dr. Rajni Gupte, Vice-Chancellor, Symbiosis International University, for their constant support. Dr. Shashikala Gurpur, Director, Symbiosis Law School, Pune, is a person who keeps the interest of Symbiosis Law School, Pune before everything else and ensures that she brings the best to the law school. Sometimes words don't justify the passion with which she works to take Symbiosis Law School, Pune to greater heights. She has always ensured that the institution provides a forum for intellectual discussions. She's full of ideas and has been the force behind the growth of the law school. Thank you very much, ma'am. This event is an outcome of a lot of background work and planning, which is done by a team of faculty led by Dr. Atmaram Shelke, Ms. Aditi Mane, Advocate Sangram Chauhan, Ms. Chaitrali Deshmukh, and Professor Kulkarni. We appreciate their contributions. They have been working for days tirelessly to ensure that this roundtable is organized in the best way. I also thank all the faculty and staff for their support in organizing this event. I acknowledge the support provided by our IT team for their logistic support. And lastly, a deep appreciation to the audience to this roundtable discussion. Wishing everyone a very fruitful time through the 2 plenary sessions that are planned for you. Thank you one and all.
Thank you, ma'am. Thank you for that vote of thanks. With this, we will conclude the inaugural ceremony and we will move directly into the first plenary session. So thank you all for being a part of the inaugural ceremony. The plenary session is on the theme, Discussion on International Law, Comparative Law and Policy Approaches to Problems and Issues Faced by Innocent Prisoners Languishing in the Jail. In order to kick off the plenary session, I would like to once again invite Dr. Bindu Ronald, Deputy Director, Academics of Symbiosis Law School, Pune, to introduce the dignitaries who will be a part of this roundtable session.
Good afternoon to all our esteemed resource persons, guests, and audience. We are looking forward to a very, very enriching discussion on the international law, comparative law, and policy approaches to problems and issues faced by innocent prisoners languishing in the jail. And to be part of the discussion and deliberation, we have a star-studded panel comprising of very eminent, esteemed guests. And I have the pleasure of introducing our resource persons this afternoon. As the chief guest of the session, we have with us Justice Dr. Shalini Phansalkar, ma'am, retired Justice of the Bombay High Court, Mumbai, and we take pride that she is also a distinguished judge faculty at Symbiosis Law School, Pune. Having completed her LLM and PhD, ma'am had joined the judicial services in 1988 and served as the civil judge junior division. She has the distinction of being the first lady advocate and first lady judge from Karad. She's worked at the Special Tara Court and Special Court for Offences of Atrocities Against Women at Pune, Nasik, and Ahmednagar. He was the Joint Director of the Maharashtra Judicial Academy since 2009 for 4 years and trained more than 450 judicial officers. Ma'am was the Principal Judge of the City Civil and Sessions Court, Greater Bombay, until her elevation to Bombay High Court on 21st April 2014 as the Registrar General of High Court. She was elevated as an additional judge of the Bombay High Court on the 1st of January and permanent judge on the 17th of November 2016. Some of the landmark decisions given by her are the Kotewadi gang rape case, the Spanish lady rape case, the Shakti Mill rape case, to name a few. Thank you, ma'am, for being with us over here today. As our esteemed panelists, we also have with us Mr. Sunil Chauhan, Director, NALSA, an LLM from the University of Himachal Pradesh. Sir is an additional district and sessions judge India and presently on deputation as Director, National Legal Services Authorities. As Director, NALSA, Sir deals with devising legal aid policies and programs for weaker and disadvantaged sections of the society. Coordinates with state legal services authorities across the country for the implementation of legal aid programs, and also looks after the administrative work at the NALSA office. Sir has worked as civil judge and judicial magistrate, as secretary, Panchkula District Legal Services Authorities, worked as joint member secretary, Haryana State Legal Services Authority, and also worked as project officer, National Legal Services Authority, New Delhi. So we are extremely happy to have you with us today. Professor Dr. S.C. Rena, a distinguished faculty at Symbiosis Law School. Sir is currently director of KIIT School of Law. He was the founding vice chancellor of Himachal Pradesh National Law University and the former dean of the Faculty of Law, Delhi University. Sir has a vast teaching experience of over 35 years, and he has inspired hundreds of students with his dedication towards law and unbounding legal knowledge. An expert of the 9th edition of criminal law organized by United World School of Law, Gandhinagar. His areas of interest are criminal law, criminal justice administration, and research methodology. We also have with us for the first plenary session, Dr. Arvind Tiwari, Dean of School of Law, Rights and Constitutional Governance, TIS, Mumbai. Sir is a PhD in Criminology and Forensic Science from Sagar University and a MA Sociology from Meerut University. His areas of interest includes access to justice, human rights, constitutional governance, criminology and criminal justice system, victimology, youth justice and security, development and crime, and has been a senior researcher for the National Human Rights Commission, New Delhi in August 1995. He has been there as the Dean Office of the Student Affairs and has contributed significantly in imparting human rights education to the various stakeholders, including criminal justice functionaries. Sir is on the board of several universities and was also elected as the president, Indian Society of Criminology, and Vice President of Indian Society of Victimology. We're very honored to have you as the panelist today, sir. We have on our panel Mr. Shrijan Pal Singh, who is the CEO and co-founder of Dr. APJ Abdul Kalam Center and is the author and public speaker, education innovator, and social entrepreneur. Professor Lasya has already introduced you, sir. You are also the chairperson of our inaugural session, and we have already gone through your profile, but very briefly once again, sir is an IIM Ahmedabad alumni and a gold medalist, and has worked as advisor to Dr. APJ Abdul Kalam, the 11th President of India. We have with us Dr. Anirban Chakrabarti, Associate Professor, Nalsar University Professor Anirban Chakravarti completed his LLB from Calcutta University and LLM from NUJS, and also has another LLM from Vanderbilt University, US. He has completed his MPhil and PhD from West Bengal National University of Juridical Science. He's the author of three book chapters and articles. And before joining NALSAR, Dr. Anirban Chakravarti was a faculty at NUJS and has also held the position of coordinator for Center of Consumer Protection and director of the Legal Aid Clinic and Community Empowerment Projects at NUJS. Gracing the panel, we have Dr. Bhushan Kumar Upadhyay, former DG Prisons and currently the Additional Director General of Police Traffic, Maharashtra State, Pune. Sir has an experience of over 30 years in the police department, an MA in Sanskrit and a PhD in Sanskrit phonetics. Sir has been Assistant Superintendent of Police, Pandharpur, Additional Superintendent of Police, Osmanabad, Superintendent of Police, Latur, Chandrapur, Jalgaon, Superintendent of Police, Rural Nagpur, Deputy Inspector General of Police, Mumbai, Joint Commissioner of Police Traffic, Mumbai, Principal Secretary, Mantralay, Mumbai, Additional Director General of Police and Inspector General of Prisons and Corrective Services, Maharashtra State, Pune, and Commissioner of Police, Nagpur. Sir has authored books and is the recipient of the President Police Medal in 2013, the DGI Ignitia 2005, the Internal Security Medal 2005, the Indian Police Medal for Meritorious Service and Special Service Medal in 2000. We are extremely honored to have you, sir, here with us, and we are extremely honored to have all our panelists, and we look forward to a very, very enriching first plenary session. Thank you.
Thank you, ma'am. Thank you for the introduction to the dignitaries. I would now like to request the chief guest for the plenary session to kindly commence the discussion. So I'll invite Justice Dr. Shalini Phansalkar Joshi, ma'am, to commence the discussion, followed by which the floor will be open to all the dignitaries to discuss the topic of discussion on international law, comparative law, and policy approaches to problems and issues faced by innocent prisoners languishing in jail. Over to you, ma'am. Justice Shalini Phansalkar.
Sorry, my mic was not unmuted. Okay, thank you. Thank you, Laksha. Thank you, Dr. Shishikala Gurpur ma'am, all the expert and dignitaries who will be present and contributing their inputs on this important subject. The subject which we are discussing is about the innocent prisoners languishing in jail. And I was really wondering, as Gurpur Madam has said, who can be called as innocent? And there can be two categories of those innocent persons. Someone who is under trial. Under trial may be at the stage of investigation, where the police have yet to file charge sheet, or those are accused who are undergoing the trial. And trial means not only at the trial court stage where the evidence is recorded and he is held guilty or not guilty, but there are other categories of the under trial prisoners also that at first stage they may be held guilty, but at the appellate court, in the High Court or in the Supreme Court, they are not held guilty, but their trials are pending or they may be held guilty. So there are under trial prisoners who are yet to be proved as innocent or guilty. They may be at this trial court investigation stage or at appellate stage. So unless and until their decision about their fate is determined, we can call them as innocent. So all the under trial prisoners at all the categories can be called as innocent, because our basic fundamental principle is that you are innocent till proved guilty. Another class of category of prisoners, which I'm more concerned with, is those prisoners who are ultimately, after the entire, all the stages of trial, are found to be innocent. And that is what is the more matter of concern to all of us. Because after undergoing many years of trial, maybe nowadays we know, and statistics, I mean, which is not adverted to and which I would like to really talk about, is the statistics which shows that more cases are pending at appellate court. And those cases, I mean, if you see, as per National Judicial Data Grid, which monitors the performance of the courts at the national level, shows that 26.55% of appeals against conviction have been pending before the high courts of the country for more than 10 years. And 27.83% of the appeals against conviction have been pending for more than 5 years. So this data it presents a humongous backlog. I mean, we know the reasons. I don't have to elaborate. The reasons are several. We always want that everything is to be decided at the earliest. I mean, we are not talking about the time which each case takes, but the time which it has to take for several reasons. Maybe the lack of judge population. We know the judge population ratio in India is very, very less, 13.5%, at the most 14%, compared to, the America, where it is 50%. 50% per 1 lakh population. We are having 3.5 per 1 lakh. So our data, I mean, judicial, everything is there. There are other reasons also, infrastructure and so many. We don't have to go into those reasons. My point is that there are cases pending, though we really sincerely want them to be decided, we can't. And as a result, under trials are languishing in jail. If ultimately they are, even if they are held guilty and the punishment for which they are to be sentenced is less than the period which they have undergone, that is again a matter of concern. So to that extent, they can also be called as innocent prisoners. And then other things, as I said, ultimately after entire trial, like Sajjan Pal Singh was talking about this Vishnu Tibari case. So after undergoing all these 15 to 20 years in the jail, if that person is found innocent, what's the use of that? That is also a matter really of concern. And we are to be worried about those cases also, in my considered opinion. So when we are talking about these under trial prisoners, we know this creates a problem of overcrowding of the prisons. And I know, though we are talking about India, the overcrowding of prisons is not a problem limited to India. When I was going through the statistics, I found that today, 2/3 of the countries worldwide have overcrowded prison systems. That doesn't justify that we are also entitled to nothing like that. But this is a systemic problem which every country is facing. And then there are certain measures also, like for petty offenses, arrest should not be done. If arrest is to be done, reasons are to be given. We have modified CRPC accordingly. We are ensuring that police do not misuse these powers of arrest. But despite that, like NDPS offenses, which we call as very serious offenses, inviting death, inviting life imprisonment, there may be foreigners also. So the courts may be finding it difficult to release them on bail. But the point is that there is, in jail, compared to our jails are constructed in the British era, so their occupancy capacity is very less compared to our overall population increase, overall litigation increase, overall, law and order problems increase. Naturally, these issues are, systemic and it has bad effects also. So which are the solutions which are found by the other countries or contemporaries, laws, etc.? So far as our courts are concerned, recently, just on 2nd of May, 2021, our Supreme Court has taken note of grave apprehensions raised by Kerala Union of Working Journalists and couple's wife about the deteriorating health of the accused in jail, said the most precious fundamental right to life unconditionally embraces even an under trial, and it does not diminish even a wee bit when in jail as an accused for an offense, and such a person's health concerns have to be taken care of by the state, and if not done so, by the judiciary. I mean, this ruling also expands what Supreme Court has said in the judgment of X versus State of Maharashtra in 2019, that right to dignity of an accused does not dry with the judge's ink. Rather, it subsists beyond the prison gates and operates until his last breath. So our constitution, our laws, our judiciary is recognizing all those rights of the fundamental rights of the persons who are kept in jail and try to protect their rights. I mean, we are trying to humanize. Also, we are having Kiran Bedi, the IPS officer, who has tried to make the conditions in Arthur Road jail, in Tihar jail prison, very humane. So we are having Upadhyay also, who has also made a lot of improvements in the prison system. But then what further to do? I mean, that is there is no, I mean, unless we find a solution, there is no end to the efforts. There cannot be any end to the efforts. And therefore, when we are considering about what others have done, and I have noticed that other states, I mean, other countries are also having some law like, paying compensation for the prosecution, which has ended into the acquittal of the case. And this right is recognized in ICCPR Article 14.6. This right is recognized by the UK system, USA system, Germany, and several others. And I'm happy to note that in India also, in the year 2018, Justice B.S. Chauhan has submitted the 277th Law Commission report, in which he has talked about paying compensation to those persons who are acquitted and who were in jail. And this report is really of importance, because when we are talking about, it may not be possible to conclude the cases of all under trial prisoners within time in the current system, especially now we know the corona pandemic has affected every system, not only the judicial system, but all the systems. And therefore, apart from having the various methods of probation, community service, furlough, diversion, parole, all these things are there. But despite that, if ultimately the accused has to remain in jail, and then he has to be, he is acquitted, then what can be done? That is suggested in this 277th Law Commission report, wherein they have suggested for payment of compensation to such prisoners. And that right, for the first time, is recognized. I mean, Supreme Court has recognized their payment of compensation wherever there is breach of fundamental right. And we are having those judgments, since long, like Nilavati Bahara judgment and several other judgments, where we are recognized that right. And taking note of those judgments, especially the judgment of the Supreme Court in Thana Singh, where it was held that for the prisoner himself, imprisonment for the purposes of the trial is as ignoble as imprisonment on conviction for an offense, since the damning finger and opprobrious eyes of society draw no difference between the two. And therefore, the various high courts, Supreme Court has also recommended the need to recompense for the years lost, for the social stigma, the mental, emotional, and physical harassment, and for the expenses incurred, etc. It was suggested that there needs to be compensatory assistance by the state to help the innocent victims of the miscarriage. And as I said, taking note of the Article 14.6 of the ICCPR, with the general comment 32 of the United Nations Human Rights Committee dealing with miscarriage of justice, it was held that these provisions collectively create an obligation on the state parties to enact a legislation ensuring that the said victims are compensated. And such compensation is made within a reasonable period of time. And as I said, many countries, including UK, USA, Germany, have converted this commitment into law, where the state has assumed statutory responsibility for compensating the victims of such miscarriage of justice. Now, this 277th Law Commission report has definitely laid down the entire framework for payment of compensation to such accused persons who are ultimately held to be innocent and not guilty as such. Now they have laid down the what amounts to such and in which cases such accused will be entitled. What can be the criteria for payment of compensation? They have also, Law Commission report has also suggested establishment of special courts for conducting such cases. Time limit is also laid down. So Law Commission has, 277th Law Commission report has really made specific legal provisions for redressal of cases of miscarriage of justice resulting into wrongful prosecution. These recommendations also suggest compensation means pecuniary, monetary terms, and also in other terms like mental counseling or some other methods whereby he can regain his confidence, he can be brought back to the mainstream of the society. So this report is really worth studying. And what is important is Commission has done a lot. Now what we have to look forward is the implementation of that report. So when we are talking of innocent prisoners, as I said, when they are in prison, we have to consider the methods of their rehabilitation methods to ensure that they are not, minimum number of prisoners are accused are arrested. We have to ensure community service. We have to make the provisions of bail more liberal. At the same time, if really unfortunately some person remain in jail and ultimately he has to be acquitted, then what we can do is we can implement this Law Commission report to ensure that at least not in any other way, but just as in motor accident case, we compensate the family members for the loss, or we compensate the injured for the loss or agony he has suffered. Similarly, here also that can be done. That is what the Law Commission has said. Money cannot completely compensate, but that is one way of acknowledging that we have committed somewhere things have gone wrong, system has not been just to him. So these are the initial thoughts which I would like to be taken forward in the discussion henceforth. Thank you.
Thank you, ma'am. I will now leave the floor open for the dignitaries to have the round table.
Maybe last year, each of the speaker may be given 2 minutes to respond in one round, and then you can call out the name of the speaker. They will speak in response to what ma'am said. They may add or defer, or she has laid out beautifully the position of law. Yeah.
So I'd like to invite Mr. Sunil Chauhan, Director, NALSA, to kindly state your position.
Good afternoon. Ma'am has rightly elaborated and pointed out certain issues and the framework also. But as far as payment of compensation to the persons who have been acquitted, who are acquitted, that legal framework is very weak in India. If you see the Code of Criminal Procedure, Section 250, section and 2-3 more sections, it is very difficult to get the compensation through civil process, one thing. And as far as the legal framework spelled out in the CRPC is concerned, that is not a practical, and you can say that does not provide the reasonable compensation, and that is never invoked. You won't find any cases. That is what I want to submit with a response to ma'am's presentation. And in my presentation I'll cover certain more aspects.
Thank you, sir. I would now like to invite Dr. S.C. Raina, sir, former Vice Chancellor, HBNLU, Shimla.
Thank you, madam, for inviting me for a comment or for my comments.
Sir, comment. We request you to comment on the position.
Madam's paper, right?
Yeah, yeah. I
Thank
think
you,
the video should be on. Organizers, please have the video on.
Madam has elaborated very nicely, particularly the part relating to compensation, because of the fact that we are signatories and we have ratified the International Convention on compensation and other things, rehabilitation. And out of that, we have to provide compensation, rehabilitation, and other things to everyone who is a victim of two things, either of crime or of abuse of power. What Mr. Singh was speaking of the two categories of people, one, before arrest, is a victim of abuse. And even after the arrest, is again the victim of abuse. So in both the categories, whether arrested properly or improperly, he is a victim. And those who are in the prison, languishing because of certain reasons, are again the victims of power. And therefore, victims of power are entitled to compensation under the international law to which we are signatories. Not only that, the Supreme Court has directed multiple cases where it has provided compensation. The reason is that we are busy with many more things, and prison being a state subject, the state has been reduced to such a thing that federal structure is no more. Thank you, please.
Thank you, sir. Who are the other speakers? Can you quickly, pass it around? Yeah.
Dr. Arvind Tiwari, Dean of School of Law, Rights and Constitutional Governance, TIS, Mumbai. We invite you, sir, to respond to the statement made by the chief guest for the plenary session. Dr. Arvind Tiwari, sir, are you there?
Okay, we can pass on. We can come back to sir later.
So we can move on to Mr. Srijan Pal Singh, founder of the APJ Abdul Kalam Center, Delhi.
Yeah, I've already spoken for half an hour, so I pretty much whatever has to be said I've already said. But one of the things which Madam was talking about was the idea that other countries also have the problem of prisons being overcrowded. The reasons for that are different compared to what India sees. India's prisons are largely overcrowded for the sheer miscarriage of justice, and I will say delay of justice is also a miscarriage of justice. The American prison system is overcrowded not for that reason. The reason why they are overcrowded is because the prisons are privatized. And America has an active lobbying system where then the lobbyists make laws be made so that anybody could be put in prison easily, because people get payments on prison are based on how many prisoners are there in it, and prisons are privatized. So different countries have different reasons why prisons are overcrowded. And our case, gladly, India does not have a private prison system, which is what US did a huge mistake. And that is the reason you see 50% of incarcerations are of Black Americans. And also, again, the same demographic that people of poverty are the ones on long incarcerations. So I think one has to look at it from that perspective. And anyways, my stated position is already that people have to be compensated. Now, if the current framework seems not very suited for that, then I think we need legislative reforms. If the court system cannot do it, then I think there should be a parliamentary reform. Under Article 32, we must do something. The miscarriage of Article 32, which is the right to constitutional remedy, should be taken up as a case where the state has not provided that constitutional, that fundamental right, and hence must compensate. And the only way, unfortunately, a state can compensate is financial. You can't wind back. You can't wound back the clock and go back 20 years. That you can't do. You can't give back their family. You can't give back their loved ones who they will never see. You can't give back their youth, but you can give back. The only thing a state can give is money. So I think that is what it should be. And I think once that starts happening, especially if you start benchmarking these, creating those landmark cases, the repercussion of that, or the domino effect of that would be that the cases of miscarriage of justice would be highlighted more. Right now, it's not a concern to us. We don't feel that there's something in English we call PLUs, people like us. And we are more concerned about PLUs. When something happens to somebody who is like me, it really bothers me because it can happen to me sometimes. I can relate to it. But people in jails, languishing, the poor people, mostly from villages, they're not PLU. We don't relate to them. We don't see our reflection in those eyes because they're different from us. And I think bringing out publications, bringing out the human angle, the human story to it, I think it's extremely important because we just don't see us in that position. We don't think it's going to happen to us. Yeah. I mean, the whole coronavirus issue has become so huge is because anybody can be affected. I could be one of them. I am one of them actually. Yeah. Right now I'm one of them. So it affects me. And that's why I'm concerned about it. I think that human side has to be brought up. And that I think compensation will bring out. The stories will come out.
Thank you, sir. I'd like to now invite Dr. Anirban Chakrabarti, Associate Professor, Nalsar University of Law.
Thank you, madam. Firstly, I express my gratitude to the Symbiosis University for inviting me to be part of this wonderful discussion session. It was great learning for me. I have just two small comments. I entirely endorse all the points that have been discussed by the previous speakers about the concerns and the challenges that are existing in this particular area. One question that has been raised and have been answered was innocent prisoner. Now, there have been 2-3 types of identification. I'll give you a small story of mine that what can be another interesting idea, another interesting example of innocent prisoners. So I was in NUJS working in the Legal Aid Center, and we had with the Commonwealth Human Rights Initiative started a program for supporting legal aid facilities to the central prisons in and around the city of Calcutta. In the Alipur Central Jail, which is one of, we call it correctional home in West Bengal because the statute is West Bengal Correctional Services, and I think the only one state which calls officially and statutorily correctional services, not jail or prison in India, if I am correct. At least that point of time, it was the only statute which used the word correctional services. So when we were working there, we found 6 persons who were all, Bangladeshi persons who have entered India without authorized, legal documents and were arrested for other charges also, along with Section 14 of the Foreigners Act. And accordingly, after due trial, they have been convicted. Now, very interestingly, when we came across these 6 persons in Alipur Central Jail, and I'm sure there will be many such numbers in different other prisons if we had done a survey in all over West Bengal, they have all completed their period of conviction. Every one of them, all the charges. We were very surprised. In fact, my students who first came across them, they came back to tell me that, sir, how is this possible? We have seen their papers and they have completed. And the problem was that what to do with them. So the moment you release them, they will be again illegal, illegally entering into in India. If you don't release them, then what? And repatriation is the procedure, which is the technical procedure which should be done. And repatriation requires functional collaboration between the Home Ministry, External Affairs Ministry, West Bengal, Home Ministry, West Bengal government, as Professor Rana very correctly said, appropriate federal structure, Bangladesh embassy, Bangladesh ministry, some organization in Bangladesh who could verify their identification and location. And these 6 people were there, and almost they were there for at least 1 year or more after they have duly completed their conviction period. So what will be their category? That's my question. We filed a writ petition saying that it was a habeas corpus petition, and a High Court judge honestly asked how is a habeas corpus because state objected. He said that there is no authority on you because they have completed their conviction. So the state prosecutor argued that the moment is released, they will be anyway again illegal and they will be again brought. So the judge, Justice Joymalo Bakchi was the presiding. They have no reason. It's a reported judgment. So he took the matter in a very, very well fashioned, and he called all of us in his chamber, and he said that I can pass an order that will only give popularity to CHRI and NUJS, and it will be not a public interest, but it will be a publicity interest litigation. So you want publicity interest or public interest? So we said, sir, we don't want any publicity, we want public. So he said that then I will do what? I will stay it at this point, make it a continuous mandamus, make it pass a direction with 3 months and create a collaborating committee consisting of representatives from various authorities, and you can work together and see how these people can be repatriated, which should be the objective, instead of passing a judgment against the state or against somebody. And we worked, and actually within 8 months or 7 months, they were all repatriated, at least these 6 people, and some working procedure was created. And then after, once everything was resolved, and Justice Bakchi passed a direction from the court resolving the petition with recording all the findings, etc. So there, I don't know what category you will put them. But my opinion, any person who is in the jail beyond the period of conviction should also be innocent. So that is one, interesting point I wanted to make to add to the category. It came from my own work. And the second thing which I want to say is, we are talking about prison plights. We are talking about delayed justice. Ma'am has spoken about statistics. We know Anna Sir has spoken about many things. Mr. Singh has spoken about many things. I don't want to repeat. But one important problem is that in 2014 in Johannesburg, there was a UN conference on criminal justice reforms by the Office of Drugs and Crimes. And I wrote a paper on that. One of the major points that emerged, where all the participant and UN member states were asked to do, was look at the financing on prisons, budget and finance. What is our national or state budget for prison services? Of course, many people will say after coronavirus, health, education, so prison, where does it priority? If the state is not prioritizing health or education, how can expect the state will prioritize something like prison or correction? But that's an important point today. We need to think about. We need to go and do an economic analysis in terms of what has been the investment, what has been the finance. We are talking about condition. How will conditions improve? How will things improve? So these are my limited comments at this point. Thank you.
Thank you, sir. You've raised very pertinent points. I would now like to invite Dr. Bhushan Kumar Upadhyay, DG Prisons and DG State Traffic Branch. Dr. Bhushan? Could you? Dr. Bhushan, your mic seems to be muted.
Can you hear me?
Yes, sir.
Actually, I think host has muted me.
So we are able to hear you.
We can hear you, sir. Again muted. Who is muted? Can I unmute Bhushan, sir?
I'm sorry to unmute him, sir. We cannot unmute. We can request, sir.
Sir, I think
Yeah, now, sir.
Yeah, sir, please.
Okay, can you hear me?
Yes, sir. We
Yes,
can
sir.
hear you.
Okay. First, I thank SYMBIOSIS Law Institute for inviting us to this webinar. Actually, I was hearing Justice Shalini ma'am. I heard Mr. Chiranpal Singh and comments and views of other dignitaries. Really, it is very enlightening to be associated this webinar. I have actually spent 31 years of active police service in field. I have worked as a prison official almost for 4 years. I was the head of Maharashtra Prison Department for 3 years, and I was DIG prison also for 1 year. Therefore, just I want to add to whatever Madam Shalini Justice had told. As far as overcrowding is concerned, it is a big problem in our country, and everybody knows. And Mr. Chiranpal Singh has commented on this issue in a very elaborate manner. As far as Western countries are concerned, some of the countries have overcrowded prison, but the number of convicted prisoners is more, whereas in India, under trials are more. And if somebody asks me what is the takeaway of 31 years of police service, I will tell in one sentence that the power of arrest by police must be curtailed. It has been pointed out so many times by the courts also, and Mr. Chiranpal Singh has also pointed out in a very emphatic way that the power of arrest is used by police to put pressure. As a police officer, I am accepting it, and I am of the strong view that despite the judgment of Honorable Supreme Court in Arnesh Kumar judgment, we are arresting the people where arrest is not justified at all. In prison of Maharashtra, where I have worked as AD's prison, I have found that so many persons are lodged in the jail where their presence in the jail is not required. There is under trial review committee under the district session judge of the that concerned district. There are members from legal aid committee. There are members from local police, jail superintendent. Those committees are working, but still I am finding that most of the people are in the jail because they are not able to get their bail. In so many cases, the bail is granted by the court, but those people are not able to furnish the surety, therefore in the jail. Maharashtra government has appointed one committee, jail reform committee under retired Justice Honorable Sri Radhakrishnan. I was member of the committee, and Honorable Radhakrishnan sir took lots of efforts. He called the meeting of the judiciary. He talked to them, and he got so many such inmates released on the bail. We approached NGOs, we collected money, and with the help of that money, so many prisoners were released. Therefore, the matter of arrest needs lots of attention, and there is no need to arrest those persons whose presence in the prison is not needed. Because if a man is dangerous, he should be sent to jail. If a man is going to destroy evidence, he should be sent to jail. If a man may escape, he may be sent to jail. But I think this matter is very urgent, and if the power of arrest is exercised judicially by the court, I think lots of prisoners may not be there and inmates may not be there. Therefore, this is my first point. My second point is that we have seen that a man remains inside jail for 2 years, 3 years. After 2 years, 3 years, he is released by the court on the bail. And even after that, for 5 years, 6 years, the trial is not completed. Therefore, here, I just want to say that if the man is inside jail for 2 years, and after 2 years, he is released on the bail, and even if the trial is not complete for 6 years, 7 years, 8 years, then I don't think any justification for that man remaining in prison for 2 years. Therefore, in serious cases where the man or where the person who is accused an offense is a danger to the society, he should be inside jail. Otherwise, other things, other offenses which are minor offenses, and even if it's technically okay to arrest a person, why we should arrest? Because our emphasis should be on conviction, not on arrest. Therefore, this concern has been very explicitly expressed by Honorable Justice Madam, and I support this, and I am of the view that the main prison reform, the main police reform is curtailing arrest. Arrest should be made only if arrest is going to serve the purpose. In so many judgments, Honorable Supreme Court has outlined so many guidelines, guidelines which are going to guide the police officers in the field. Accordingly, CRPC is also modified, as mentioned by Honorable Ma'am, Salini Ma'am. But again, this is not happening in the field. Therefore, what we can do, in so many cases, we have found that police officer is not held responsible if a legal arrest is not there. Because just he's arrested, he's sent to jail, he remains in jail, he's out of the bail. But nobody, but wherever I worked as a unit commander, I was police commissioner Nagpur, I was police commissioner Solapur, again I was SP of Soni district. My first command to all police officers in my first crime meeting was that arrest only those persons who are dangerous to the society. If the arrest is technical, don't arrest anybody for the technical thing. See that that man is convicted in the court. Don't emphasize the arrest, emphasize the conviction. And that is the main thing, I think, which may do something to the criminal justice system, police reform or prison reform.
Thank you, sir. I see that Dr. Arvind Tiwari is here. So, sir, could we have your views on the theme?
Thank you very much. Good afternoon to all of you. Professor Gurpur, esteemed panelists, ladies and gentlemen. Much has been said. I would like to just highlight few points because I am also in another session in which I'll come up with some ideas. Now, there are 2-3 scenarios regarding this. As Dr. Padhya has rightly said, that the arrest is one area which has to be seen, and several judgments, D.K. Basu and Joginder Kumar judgments and guidelines are there from Supreme Court. National Police Commission has also said 40% arrests are being made unnecessary by the police. But the scenario, if you will see the crime scenario in our country today, and particularly if you see the crime against women and children, and see the number of under trial prisoners, if I'll quote the prison statistics of 2019, that you see around 63.7% under trial prisoners, those who are in the prisons, have committed offenses against affecting human body, and 59.8% are charged, alleged for rape, and also 23.1% for dowry deaths, etc. So if you will see the current crime scenario, there is a need to reclassify the crime, this bailable, non-bailable, and other kind of classification. We have a national policy on prisons, national policy on prison and correctional administration in 2007. But there is a disconnect if you will see the various subsystems of criminal justice system. Police is being the frontline agency. Sometimes is also in the very fixed position. What to do? Because the crime, according to law, would be minor. But I was conducting a study in Mumbai regarding bail and the recidivism. And many police ground level officers told me that you see, although the crime may be bailable, but if the person is being released by us, by the police on bail, because this is bailable, the message is not going correctly to the people, and people feel, oh, nothing has been done by the police has taken money or something like this. So what I am saying, that there is a need first to look into the arrest, to reclassify the crime, and criminal code also. At Professor Madhav Menon committee in 2007 has said that we need several codes. There is not only the one CRPC, we need 3-4 criminal codes also, and we have to reclassify the crime because we all know that, you see, the rich people are not going to the jail. Even as under trial prisoner, they manage the bail. And the poor people, I will not say all are innocent, but yes, technically and legally, They are innocent because we have to process their cases and we have to decide. So that is the responsibility of the state to speed up the process. But at the same time, like judiciary, for example, the use of probation. Now, in many cases, eligible cases, use of probation is not done. We have to reintroduce the sentences like community service. In petty offenses, there is no need to arrest, and people should be asked to do the community service. So what I would like to submit, that there is a need to look into the whole component of all police, prosecution, judicial processes, and prisons in a holistic manner. Although there is no dearth of committees and recommendations sector-wise, but there is a need to have a national commission on criminal justice reforms, and also to look into in a holistic way all these issues and see that how we can diversify. Decriminalization also is needed in some of the offenses which are now not needed to be criminalized. So decriminalization process has to be initiated. So there is a need to look into holistically the whole process, including the policy on arrest. And therefore, the matter, the people, those who are really sent to the jail, they should be sent, and not everybody, those who are doing petty crimes, they should be sent. But at the same time, the societal perspective we have to see. We'll see the crime against women and children, hate crime, caste atrocities, criminal violence. All these issues are increasing too much. Now, there are two kinds of people. In criminology, we say crime doesn't pay, but for some criminals, crime pays. For the white collar offenders, for the criminals, those who are making money through criminal activities, organized crime, they are not in the jail. So you see that our entire system is focusing on the poor people. If they have committed crime, although anybody will commit crime, one person should be punished. But I think there is a need to relook the whole system also, and the white collar offenders and the serious offenders should be brought to the jail, and some other like mechanisms, community service and other modes, restorative justice model should be also adopted in the justice system, so that the people, those who are really innocent and those who have been framed and put in the jail, can be saved, and also compensation to be paid to them. Like in Akshardham case, Honorable Supreme Court has said that although they are innocent, but could not directed to pay the compensation. But in S. Nambi Narayan versus C.B. Matthew, in this case, Supreme Court has directed 50 lakhs to be paid by the Kerala government. Similarly, in Maharashtra, Ankush Maruti Shinde and others versus State of Maharashtra in 2019, the 5 lakhs compensation was, the court had directed that this should be paid to the people, because they have spent their most of the time in the prison. So many, it is not necessary that the person who are charged for the crime, if is convicted, not convicted, has not committed the crime. Fair investigation, for example, is also equally important, whether fair investigation is done by the police or not. So I think there is a need to look into in a holistic manner the entire criminal justice system and the processes, and we should see that the innocent people are not, since beginning, are being arrested. If they are arrested, they should be getting the bail. Thank you. I'll come later on in my second session. Thank you.
Thank you, sir. We see a few questions in the chat as well. So to moderate the question and answers, and also to deliver the concluding remarks for this session, I would like to call upon once again Dr. Shashikala Gurpurma.
Thank you very much, Honorable Justice Shalini Pansalkar Joshi, who assumed the role of a chief guest and prime speaker as a plenary speaker for this part of the roundtable. And I also profoundly thank Professor Tiwari, Professor Raina sir, Dr. Bhushan Upadhyay sir, and all the panelists who have responded suitably, especially Professor Anirban as well, with a live case from his experience. Now, overall, the theme of the session was comparative dimension, which Shalini ma'am brought out very effectively in terms of how our judiciary has towed the line of most of the precedents across the world, inspired by the international precedents and conventions on human rights. Now, for me, if we look at jurisdictionally, it's very interesting to see beyond the court developments as well. I came across a project called Innocence Project, which very much sits with what Srijan sir was saying. In terms of a 360-degree view, keeping the innocent prisoner in the center. If we do that, then I think some of the ideas that he plotted and he showed in his first address are very important, which is, I think, overall well-being of that prisoner who is in the center, which is in focus in the Innocence Project in United States of America. Probably Professor Tiwari would have come across this as a criminologist who looks at criminal justice administration rather than us law schools who are mostly into the technicality of rules alone. So here, across different states that US has a federal system like us, how they are looking at compensating those who have been wrongfully incarcerated or those who have been wrongfully kept in the prison beyond the term. Or in India, maybe we can have other issues as well. We had long ago Rudal Shah case, a number of other, Neelabati Bera, as ma'am mentioned. Now here, I think we need to have a very structured project. Certain funds from the state needs to be reserved for that. I don't think it's a huge fund. I was reading, watching a lot of documentaries in, this Al Jazeera television, Al Jazeera, which is a kind of international television, where there was a very, very touching documentary, which talks about the orphaned state of these prisoners once they are out of their prison term. They are not trusted, they are not wanted, they have lost the social network. So eventually it kicks in worse mental health problems and they could once again go back to the prison. So these are the issues that if we want to convert them as effective social capital, human capital, and if we want to do our duty as fellow citizens towards them, and if the state were to exercise its responsibility. Now, internationally speaking, we are in the trap of being a developed country who does not, a developing country who does not have the duty to realize socioeconomic and cultural human rights. We have progressive realization duty upon us. And it did not lay down, the International Covenant, any timeline for that, because it assumed that once the country goes through that economic challenges, when it develops, it automatically comes into a level of realizing these human rights. Unfortunately, it has not been happening. We have stray incidents of Tata Trust or others as richer lot within a developing country coming to bear the brunt of this social responsibility. There hasn't been much. So what is the Innocence Project going to be? So I suggest that the outcome of this should be a project in the line of Innocence Project, piloted at every state or taken up by the central government in collaboration with the states, out of which prisoner-centric or the accused-centric or trial prisoner, under trial prisoner-centric or innocent prisoner-centric approach can be taken. And I think in the second part of the roundtable, definitely Professor Bajpai, Professor Tiwari, and our own study will show how those on the death row are usually those who have come from abject poverty. And I believe in that theory of what I call as Chambers theory. Chambers has articulated this theory. The whole rigmarole of poverty, depriving political rights, depriving economic rights, depriving access to education, access to other realization of rights, and leading to a kind of mental state whereby committing a crime or being in the crime scene, not being able to defend is an automatic offshoot of that. Therefore, overall, till we succeed in addressing the poverty, I think the state has responsibility for these people. Therefore, how should the Innocent Project be coming up in India's context is the challenge that I would request our team to take up with the help of these panelists to take it further. Now, I'm very happy to direct some of these doubts and questions from our young students and the participants. First is a kind of comment where Mr. Nasiruddin Lohar talks to Srijan sir, probably after his first talk. Fantastic session. Share your email ID. We being prisoner officers or concerned people can communicate regarding the points you raised for constructive conclusions. Second is about Asha Singh, who says that whether the government can provide an employment to the accused who has been acquitted free of charge after languishing in jail for years, because that becomes government's own folly. So shouldn't government provide means of living? Would any panelists like to respond quickly in one line?
Here I would like to say, because 277th Law Commission report of 2018 suggests pecuniary as well as non-pecuniary compensation. So pecuniary in monetary terms and non-pecuniary assistance, they said that it shall also include a specific provision for removing disqualification attached to a prosecution, particularly affecting wrongful. And it also says that a wrongfully accused person chances of finding employment in public and private sectors, and also getting him an admission in educational institution. So at the most, what the report suggests is that we will remove the disqualification, but it doesn't say that we will give him the service as such. That is what I mean the Law Commission report's present framework suggests.
Thank you, ma'am.
Ma'am, I'm Animan. I just wanted to make a very small comment on this point, because one of my students who has done his PhD has made this comment. I found it viable. One point already Justice ma'am has pointed out, disqualification, rather incentivizing or disincentivizing. So disqualification is one point that Law Commission has already suggested. Another point is, if you look at the recidivism, one of the reasons for that is that once you are, once you are released, you have to find an effective way of resettlement.
Yeah.
So the Nelson Mandela rules, which is now applying on the UN prison, talks about 3 Rs. This is rescue, rehabilitate, and resettle. Though applies principally for juveniles, but we can take to the even adult offenders also. So resettlement process is important, and from our very empirical studies that we have done on release of people on bail or others, they have faced too much social traumatization, secluding them, and all sort of ostracization. You are a sort of prisoner. Even when they go in their home, their family members are not willing to accept. With the women prisoners we have seen. So there has to be a critical role of the state, and that's where NALSA has to expand its objective, NALSA and its institutions.
Yeah.
The social organization has to come. So I absolutely believe employment is a very important factor that we need to think about in order to reduce recidivism also.
Thank you. Very good, Anirban. Anybody else who wants to?
I want to say something on
this.
this.
Region, please. Yeah.
Let's be realistic on this. Asha has raised a very good point. There are two issues to it. Private sector will not employ people who have come out of jail, and the government can't force. The government cannot force a company to employ people who have come out of jail. The government can put a directive that don't discriminate, but then people will find out, and eventually there'll be, even if it's not the discrimination at the point of entry, it'll be when later people find out, there'll be discrimination. Number two, what do you do for cases? For example, Vishnu Tiwari. If a person spends 5, 10, 20 years in prison, where will he get a job now? How will he apply? Where is he qualified for? He's aged out. He's done nothing. There is no education qualification he has, which he can apply for a job. There is no skill. I think one thing we need to do is that train proper skills.
Yeah.
Educational opportunities in prisons are important. If you don't do that, then how is he economically productive at all? So, and the third thing is that you don't, so Asha's point is about job. I want to expand that. It's about livelihood, what Justice Shalini was saying. It's about livelihood. Livelihood does not come necessarily by a job. A lot of these prisoners are rural folks. They are people from villages. Maybe you can give them certain assets to do something, They can run some business, some venture. Today we have Mudra loan. You have priority sector lending. Why don't we talk about that? Maybe some of the Mudra loans can go to people who have served their sentence from the jail. And even if the person was guilty, they served it. Why don't we use the financial tools we have to help these people stand on their feet? That we could do. And it's extremely critical. See, it's not, so even if I was a selfish man who just worried about myself, and if all of us for that way assume that, I'm sure we are not, it's in my best interest that a person coming out of jail is rehabilitated. Because if that doesn't happen, then people have to live. Then he'll do something even worse. This is what will happen. So it's in my best interest that people coming out of jail find some livelihood, whether it's entrepreneurial in terms of small businesses, whether it's a job, and for job you need a training. So all those things have to be. So it's a very good question, but it has a very wide answer. It can't be. It's a whole discussion on its own.
Exactly. So, given the kind of mental state of mind they are in, I think a kind of hand-holding initial transition will have to be supported, even if you're talking about entrepreneurship, and not denying them the opportunity becomes more important. Now, I'll take you through another question, all of you, Madhubrata's question regarding expenditure made on prisoners across the jail. Madhubrata, we had a master's student who did this study based on CAG reports, and he was showing very clearly how the heads of expenditure and actual expenditure do not match, and how jail manual needs to be more prisoner-centric. So, or whoever is there, their well-being has to be in the center. So, anybody wants to answer this question? Maybe Nasiruddin or Upadhyay sir or somebody who is in actual role of prison management.
Good afternoon, everyone.
Yeah.
I would like to answer the question. She can get the data from the NCRB report, which is prepared in the 2019. Much detail about the prison is given there. So, prison statistics, which earlier one of the dignitaries mentioned it. She can get the data from there. And I'm so surprised to see that there is no prison officer in the discussion about prisoners. So there is no officer from prison cadre. There is no officer who has superintendence over any prison. So you just can't see the reality of any prison inside. See, there are many points raised. First is the officers, when as Srijans are told, like we need to reform the inmates. When they come out, there must be chances for the employment and everything. So in those countries where we see that prisons are giving good results, take it as Singapore or any other country, there the staff, the officers and the staff of the prison is motivated enough. They are trained enough, sensitized enough to treat the prisoners in a better way, to reform them. Now here the department and the officers of prison departments are ignored so much. They are not given much importance. They are not given enough training, I would say. So this has been a problem. They are not much sensitized to treat the inmates in a better way. So they take it as a custody. The other thing, like earlier it was told about arrests. Now, police stations are given reverse targets. Like there must be 100 cases of liquor in this particular month. This is not the way how it should go. They should be told that there should be no case of liquor. They should prevent it. Now the officers are instructed like they should file 100 cases. So what they will do, they have old record, they will go and find those people and they will file a case and arrest them. And that's why you see the people inside the prison under trials are more from the liquor and narcotic cases, which was mentioned earlier in the presentation by the students there. And as far as employment is concerned, I would say that prisoners, the prisons across the nation are running their industry. You take Telangana, they have turnover of 599 crores. So they are training the inmates and they are running their own industry, and they are making it sure that when they go out, they get employed. They are having, even in Gujarat, I'm from Gujarat prisons, I'm principal of the academy here. And we also are making sure that when any inmate go out, we have tie-up with industries. And we try to see that he is employed because we give training. We give them training in our industry.
It's very heartening to hear that. Next session will be on best practices as well. Could we reserve a little bit for that? So
Sure.
that we
And one more point I would like to make in presence of Honorable Shalini ma'am, that as a prison officer, I have seen that the DLSA, that is State Legal Services Authority or the District Legal Services Authority, has been kind of failure. As in Gujarat, for last many months, I have seen there hasn't been any case on of release under 436A, or even the lawyers being provided by the Legal Services Authority are of not that quality which is required. You won't find good lawyers in that small amount of remuneration which we are paying. So we can include bar association, and we can make it a rule like each lawyer must take one case each year, or like that, so that we can get good lawyers. Even some of my friends who are judges in the district courts and others, even they complain like those lawyers who are appointed by the DLSA don't know how exactly to represent the case.
Yeah.
This has been a problem for the inmates. On one hand, we are giving them service, and the quality of service is not that good, so they are suffering. So this was my point. Thank you so very much.
Absolutely, quality suffers. And I think we were talking about Lok Adalat in Karnataka. Such Lok Adalats, prison Lok Adalats are not happening very effectively across many states. Now, there is...
Ma'am, I would just like to intervene. Quality of, legal aid services suffer because the remuneration paid to them may not be of, the criminal lawyer of high practice, high repute, how much he must be earning and what he will get by conducting these cases. But one way found out by our High Court, Bombay High Court, is that, whatever work you do as a legal aid counsel or for legal aid services, that work is considered for conferring the senior counsel position. So, we consider when we confer the senior counsel status to particular advocate, we consider whether he has done any legal aid work, legal services work. So on criminal side, they make it a point to do some case, appear in some cases at least, for and on behalf of the, under trial prisoners as a legal aid counsel. So some ways have to be found out how to do.
Yes, ma'am. Yeah. Even the Bar Council has a duty here, not only the judiciary, that putting such qualification to renew the licenses, for example. See, for doctors, they have to do that. Why not in our profession? Now, coming to Namrata's question, amid pandemics, various courts like Delhi High Court have granted interim bails to under trials to decongest the prisons. While granting it, it undermines the prolonged languishment and delayed justice to under trial, does it? Secondly, with regard to protecting the right to health, whether the limited nature of interim bail is good enough. So will it turn out to be an effective remedy? Anybody wants, I think it is finally Dr. Shalini's cup of tea. Yeah.
But problem with granting interim bail is that if the accused does not return, I mean, I was reading some news items wherein the prison officials are really worried that they have released the accused due to pandemic, and now those accused are not returning back to the jail, and it has become difficult to trace them. So that is one difficulty of granting the interim bail. And if he is not given regular bail, then interim bail can be granted only on medical grounds or on some emergency or some death in the family. So it is not so easy as such to grant interim bail when regular bail is not granted. So the same considerations apply, and there should be guarantee. Then the bail amount, PR, security would be on higher side because there should be some guarantee that he will return back. So again, the same considerations. But it can be resorted considering the present situation of pandemic or such exceptional situation, but not on regular course.
Yeah, really. Here, we have very interesting, a few other questions, but I'm just truncating it. I really thank those respondents who have written very good questions, especially the one, this is on the countervailing side, Rohit Kulkarni, who is concerned about death penalty or death row prisoners using the delay tactics, like how they did in Nirbhaya case. So because of the unavailability of hangmen, what could be the remedy in such cases? So this is one suggestion, one concern. The other concern is about introducing compulsory legal aid, which we have already addressed. Then somebody talking about, that is Madhubrata again, compensation for wrongfully accused people. Should state decide? That part we have discussed. And here is Professor Ashutosh Panchpai commending Dr. Upadhyaya for his valuable contribution in introducing Vipassana, etc. Incidentally, we have Miss Monica Dhawan here from Dr. Kiran Bedi's organization, who was a pioneer in such character building exercises. And today she'll discuss some more things in this line. So congratulations to Dr. Upadhyaya as well as Monica and Dr. Bedi's team as well for introducing it. Now, somebody said, what if the prison workers, inmates who are engaged as temporary workers do not get minimum wages? Most states do not comply. So how do we deal with that? So these are some of the questions. If anyone wants to respond quickly, you can, so that we move to the next session in next 3 minutes. We have Dr. Harish.
Can I briefly respond to this question, wages?
Please.
Yeah. Actually, there is a judgment of Honorable Supreme Court on State of Gujarat versus Honorable High Court of Gujarat in 1997. There was a long debate on this issue, whether they should get the minimum wages or not. And the court has finally said that the minimum wages cannot be given. However, the wage structure should be revised. And therefore, I would advise my students and other colleagues, please refer the Prison Statistics 2019 published by NCRB, gives the entire table that which state. So there are broadly 3 kinds of wages: skilled, semi-skilled, and unskilled. And one portion of that, according to this judgment, goes to the victims of crime also, and also one portion goes to the offenders, those who are putting to the work. But many jails in our country, they do not have enough work to be done by prisoners. So, and under trial cannot be compelled, as we all know. Under trial can only volunteer if they want. So mainly, there is a need to strengthen the vocational training and through skill development program, etc. of the government of India and other state governments. Thank you.
Can I intervene for a minute?
Yes.
Some more light. Yeah, as Sir told, the rules for the wages are being revised in almost all the states now. And hopefully, as the pandemic has been here, it has been tough to go for the proceedings. But by the end of this year, hopefully all the states across the nation will revise this wages structure. Kerala has already revised, and they are paying a bit more. But as Srijan sir told, like it's not nothing compared to this Manrega even. So as the decision of High Court is that they can't get the minimum wages, but we just need to revise the structure. We are revising the structure. And as far as the skill development and trainings are concerned, the prison departments across the nation have tied up with the IITs, RCT, and other institutions, and they are giving skill trainings and they are giving certificates as well, which doesn't mention the center as a jail. So they are given a certificate without mentioning their being in the jail. So it has been helpful, and we have many inmates, exemplary inmates, who are working as journalists, who are working in private sectors, and they are earning well enough for their family. Thank you.
Thank you. That's a great information. Anybody else?
A minor legal point to what Professor Arvind was saying. So that's true that people, the wages which they get are low, and a part of it goes to the victim. That is true. And when I was, I think 25% or something goes in case of a victim of rape or something. Maybe it's different for different offenses. You will know it better. What do you do in case of Vishnu Tiwari, when after 20 years of work and paying for falsely accused crime, now he's already paid to the person, and now he's innocent after 20 years. How do you get that money back, which he has transferred to somebody who had falsely accused him? I think these points are human justice.
Yeah, they're unanswered ends in justice. Yeah.
Nobody will see that technical loop in it. Even Vishnu Tiwari didn't. Now that you said it, abhi mere ko aaya ki this is also a point. Even that person who was paying it doesn't even realize it. I should get it back. But nothing.
So formulation of a litigation for that purpose with all our experts.
You said one thing very nice, and how do you get? In fact, Justice Shalini was also talking about people don't want to work for legal aid because of the money or other factors, and everybody's saying that. See, these doctors in this country, they're supposed to serve 1 year in a compulsory rural medical immersion. I think lawyers, before they are registered for Bar Council or something, they should work for 1 year as a legal aid. These young students should perform there, and that will become a good benchmark for them to find employment with top legal houses. then they will say, okay, this guy has, this little young chap has done really well as a legal aid. So his argumentation is very good. Abhi, what is the recruitment pattern? You're recruiting in terms of basis of marks or maybe MOOCs, whatever the moot courts you have. Maybe I don't know what is it. How does a legal firm recruit? You would know it better. But why don't we do it like an internship 1 year, like doctors do it, and like in IIM we do it. So when I graduated from IIM Ahmedabad, 60% people get a job based on 2-month internship. You don't have to sit for your final placement. So something like that we should, because see, it's
we have in the law school. Our students go to top-end law firms and business houses.
It should be something the bar council or they should just make it 1 year mandatory service.
I agree with
we're doing it out of because of your good heart, but I think not everybody is doing it.
Yeah,
everybody should do it, and there are enough cases to solve.
Yeah, Anirban, would you like to intervene here, because he is also like us? He's forcing students for pro bono. Yeah, go on.
I would like to say one thing about the on the question of the payment of remuneration. Now, as we know, even the Nelson Mandela rules do apply now, and it's now the benchmark. So, Rule 103 of the Nelson Mandela rule says that it should be equitable remuneration for work for prisoners. So, it's not the question of minimum wage or not minimum wage, equitable remuneration.
Fair.
And what is equitable should be adequately, decided. I think Mr. Nasiruddin had said. So state has a, all these factors that which was raised, inflation and all should be kept in mind, etc. Due, it should not be servitude, etc. So keeping that in mind, the word is very clearly stated: equitable remuneration. So it should be equitable, not equal. Equity. So equity is not equality, we know. So equity should be in point. So that's point one. So I think remuneration is an important factor, but more than remuneration, more important is appropriate training and facilities should be given, which is due. Now, one question was about what they do when they come out, etc. So I'll give an example. There was a very famous drama. She was a choreographer and all, very famous from Calcutta. And she worked with the prisoners of the central jail in Kolkata, and they produced a wonderful play which they took it to everywhere in India. Not only all their play were inmates, it was a Rabindranath Tagore's Valmiki Pratibha, and it later became a movie also. It's a Bengali movie. And the person who was the lead character, he was a convict, a murder convict, if I correctly remember. And now he has become one of the most prominent film stars in Tollywood industry.
Great.
So, when we talk about employment, it doesn't mean that I agree entirely with Mr. Singh. That doesn't mean that employment means you have to give a 9-to-5 job in a government office. It can be different ways. If you give him a proper environment and a proper training. His name is Nigel. He's a very famous actor now. In Calcutta, Tollywood industry, has done 2, 3, 4 commercial movies independently other than this venture. This venture itself became a movie. So there can be, a lot of incentives that can be thought about. And another point is about this, one thing that we have not discussed till now, maybe in the next session, this 436, this bail provision. There, I think our district courts can do a wonder. The legal services can do a wonder. But somewhere we are not able to tap the full-fledged. Even our law schools can do a wonder for them. Technology can come. Mr. Pal was talking about technology. Technology monitored, technology driven. 436A is a great provision. It was introduced by the Malamat Committee. But even till now, we have not able to convert the full potential advantage. So that needs to work. That is my humble suggestion. And the law school have to play a very important role in that. We can directly play a role, a very important role. Our students cannot be, that they decide themselves to corporate or criminal lawyer, but they can play a very important role in just implementing 436A. In a proper manner, and that would reduce, at least in my opinion, 50% of the prison population, and judges have to be also a little bit open. Justice Krishna here said jail is exception, bail is rule. But unfortunately, our lower judges, our subordinate court, I should not use the word lower judges, subordinate court judges do not understand that to that extent. Somewhat they leave it to High Court and Supreme Court for that application of bail is the rule and jail is the exception. So they believe jail is rule, bail is exception.
However, Dr. Anirban, there's a lot of emphasis in the Judicial Academy now on the human rights dimension.
I agree, ma'am. But still, I have seen in practice, judges do not, to that extent, are open in the subordinate judiciary. More because we have moved to High Court, we have got more, open judgment. Even in Bombay also.
As a legal system, we seem to be believing more in quick fix ad hoc solutions, such as being strict in our punishment rather than reformist. We don't have the patience. So here, somebody is drawing the attention, Harsh is drawing the attention to Justice Amitava Roy committee that there should be at least one lawyer for every 30 prisoners. So given the kind of situation we have, maybe some of the suggestions you have given, and also one of the students here says that the seriousness of the discussion here, it need not be, discussion here, it need not be that law students should go to law firms. They don't learn anything compared to this kind of practical thing. Dr. Hari Shetty is asking, what are the 3 important initiatives we should take? I think from the discussion, it's very clear in terms of wage, in terms of bail, even the protection through video evidencing. That was a suggestion which came in order to avoid, those risks while being taken to the court. So with that, we bring the question and answer session to the end, and let's move on to the next panel, because we were supposed to close at 5, but it started a little late. So I'm sure people like Dr. Shetty will bail us out, and you could speak first, sir, because your dimension will be very different from what has been discussed so far. So I request Professor Lasya to come in and give the call for the next panel, please.
Yes, thank you very much, ma'am. Thank you to all the dignitaries for your insightful and solution-driven deliberations for the first plenary session. We will move on quickly to the second plenary session. The theme for the second session is analysis of data, case studies, and global or Indian best practices on innocent prisoners lingering in the jails in India based on empirical studies, including prison courts and clinics. To introduce the dignitaries, I would like to call upon Dr. Bindu Ronald, Deputy Director, SLS Pune.
Thank you very much, Professor Lasya. We now move to the second plenary session on discussion on analysis of data, case studies, and global and Indian best practices on innocent prisoners lingering in the jail.
Bindu, you're not audible, so you can be brief and brisk so that we start with the deliberations. Yeah.
Am I audible now?
Yeah. Now you are. Please. Yeah.
We now move to the second plenary session, and we were supposed to have Dr. Kiran Bedi to lead this session as the chief guest for the second plenary. However, due to some pressing matter, ma'am could not join us for the session. In the second plenary session, we will have with us on the panel Advocate S.K. Jain, a very eminent criminal law advocate in Pune. Sir has a practice of over 48 years, and he is the president of the Nirmaya Trust, Pune, that works for the upliftment of slum-dwelling children, especially girls, director of Century Enka Limited. He is the patron member of Science and Technology Park, Savitribai Phule University, President of Advaitika Parishad, Chairman of Advisory Committee of Apang Kalyan Kari Sanstha, and many others. We have with us on our panel Dr. Arvind Tiwari, Dean, School of Law, Rights and Constitutional Governance, TIS, Mumbai. So was also on the panel of the first plenary session. We once again have the privilege of having on the second plenary, Dr. Bhushan Kumar Upadhyay, Additional Director General of Police Traffic, Maharashtra State, Pune. Sir was also there as a panelist on our first session. We have with us Dr. Hari Shetty, a renowned mental health expert, a practicing psychiatrist with a postgraduate degree in psychological medicine and a postgraduate diploma in comparative mythology from Bombay University. Sir has a rich experience in various areas of mental health work. He was appointed a consultant at the Sevadhan De-Addiction Center and the National Addiction Research Center by the government in 1989. His petition with the Maharashtra Human Rights Commission to abolish the segregation practiced in schools was accepted and segregation was abolished. Sir has been the star witness in the infamous Panvel and Thane orphanage cases of sexual harassment abuse where convicts were penalized. A very warm welcome to you, sir. Once again, in our second plenary session, we have on the panel Mr. Sunil Chauhan. We also have amongst our esteemed panelists, Mrs. Monica Dhawan. Ms. Monica Dhawan is a social sector entrepreneur and director of India Vision Foundation. She has enjoyed a fulfilling career as a director since 2012 with India Vision Foundation. Ms. Monica is a master's in social work, and her association with India Vision Foundation started as a fundraising raising manager in 2007. Throughout her professional life, she has been a guiding force for her team, practicing the mantra of bringing and spreading happiness and hope. She's trying to make a difference in the lives of inmates and their families with the efforts of her team. She's a member of Punjab Prison Development Board. Her contribution has not only taken the work of India Vision Foundation to national level, but it has also helped the foundation to gain international presence. She believes you were born with the ability to change someone's life. Don't ever waste it. I call upon all the experts to provide their views on the topic and hand over the forum to Professor Lasya.
Thank you, ma'am. I would like to call upon Dr. Shashikala Gurpur to moderate this session, and we'd call on Dr. Harish Shetty, who's a mental health expert, to kindly come in and share his views on this theme.
I've really been inspired and happy at the presence of learned speakers, learned a lot across time. But when we look at innocent prisoners, there are three things which come to my mind, as Honorable Justice had said in the morning. I have seen a lot of people breaking down just because they have been in jail for some time without any reason. And most of the false cases which have been put across, many of them have been mentally ill before they were arrested and jailed. I recall this famous case of Pune when a bus driver ran amok and killed many people. His case was a case of pure bipolar disorder, which unfortunately people across the law enforcing agencies did not understand and were not able to grapple with that entire case. It went to the High Court, and what happened is known to everybody. I still remember a boy who was to steal motorbikes, and leave it after the petrol got exhausted, and would just go home. And one day, when the police officers of a particular police station could not arrest anybody for a loss of bikes, not taking the bikes to one place to another, but loss of bikes across the city, they arrested this boy and charged him with various offenses which he had never done. He had bipolar disorder. He went in his face of excitement. He would do this, and then slowly when he became depressed, he would come down and he would go back. And these are not the only cases which actually happened in the city of Bombay or the state of Maharashtra. If you look across these cases across the country, there are numerous people who are mentally ill, probably who have not done anything, or probably they have done something very little and have been arrested. Now, when you look at these cases across time, mental health awareness inside the prisons are completely missing. I had the opportunity to work in Thana jail on behalf of a Gandhian foundation, and I found that there is completely lack of awareness. Unless somebody attempts suicide, unless somebody attacks somebody, there is zero awareness on mental health. When we look at innocent prisoners, and we, as somebody said very beautifully, I think Mr. Singh, basic jurisprudence is about protecting the innocent and punishing the guilty. I think that one sentence has hit me, and the case of Mr. Tiwari will stay in my mind across my life. One intervention which is absolutely essential is screening the prisoners also for psychiatric illnesses, not when they become violent or not when they hang themselves inside the jail. So what is the outcome of this intervention? The outcome of this intervention will be that probably all reforms which anybody is aiming cannot happen without reasonably sound mental health. Now, if you look at all these prisoners, studies across the world have shown many have borderline personality and antisocial personality disorder. Now, though as a philosophically, I believe that transformation is possible in every human being, irrespective of who he is or who she is. And when I say this very strongly, I have seen that happening across my life in my own interactions and interventions in the field of social work and not only in the field of psychiatry. But if we adopt principles of science, law is a science, we adopt it, we think about it, we are dynamic about its implementation, and we go ahead and talk about its implementation with rules and with other case reports, case evidences, and evidence across the world. So what is wrong if you also are mentally aware about the prisoners? When I was working in Thana jail, I found 3 groups of prisoners. One group, one small offense, they did not know what happened, and one offense, single offense, and they were moving up and down, and they were completely lost. No counseling, no vipassana, nothing was happening. The second was repeated offenders, whose main aim was to see to it that the mothers are told that they should be bailed, sureties should be given. The third offenders were gangsters of prominent gangs, were very well fed. In fact, when I went to this section, I found I got a lot of dry fruits and milk. I don't know from where they could get it. So all reforms cannot happen in a corrupt jail system. All reforms cannot happen without looking at the mental health of people in the prisons. Lastly, I would like to say that what is very important when you talk about innocence, innocence is also about an accident, and accidents can also happen which are politically motivated in certain areas, and a lot of this happens when people who really are victimized and they're innocent belong to the marginalized societies and also to those who are mentally ill. I would suggest very strongly in this seminar that 3 things can be implemented in the jail system to understand and to see to it that whatever reforms people are speaking about can be implemented, and the innocent who are inside for lack of facility or lack of surety or even a lack of legal aid can also be counseled, which means let us screen people who are in the jail for mental health issues. Let's provide mental health care inside the jail, and not only psychiatric care in mental hospitals. And also, what is also extremely important is that let us convert jails into compassionate, into place of compassion. And compassion cannot happen in dry air. Compassion cannot happen only by love, affection, and good food. Compassion also can happen only when science is introduced into the entire process. I would also suggest that all people inside the jail, right from the superintendent of the jail, etc., from down onwards, are aware of emotional issues, and these issues will help reform as well as upliftment of the jails to a very great extent. With this, I stop.
Thank you, sir.
Yeah, brilliant, doctor. I mean, this is something, even we did medical camp, but we did not do screening for mental health, which would have been the first step, Thank you for that. Let's go to the next speaker, which is Monica, I think, in the waiting, right? Who didn't get the opportunity. Yeah.
That's right. So we have Ms. Monica Dhawan, Director of the PRISM Program India Vision Foundation. Over to you, ma'am.
Good evening, everyone. First of all, on behalf of Dr. Bedi, I would like to apologize to Gurupur ma'am for not her availability. Something unavoidable came up, and that's why she has to leave for a meeting urgently. So I really apologize on her behalf. You know, she is so excited about this seminar, and she prepared her notes also, but unfortunately, she could not be a part of it. So I regret her presence for this session today. So, ma'am, India Vision Foundation is a 26-year-old organization, as we all know, founded by Dr. Kiran Bedi. And at presently, the foundation is working in prisons of Delhi, Haryana, Uttar Pradesh, Punjab, and we just started working in Yerwada prison before the pandemic. So we could not start our initiative, especially with the female and the children, which we want to do. But unfortunately, because of the pandemic, we could not do it. So presently, we are reaching out to 3,000 inmates inside prisons every day through our various reformation model. And as Dr. Bedi has initiated the reformation in Teha, which are very humane in nature, and help them not only use their time constructively while they are inside the prison, but also help them into rehabilitation and reintegration back into the society. So the foundation, as I was hearing about the other speakers also, and mental well-being is one of the mental issues are the most important and the prevalent issues, which is seen in especially in the under trials because of the delayed justice. So we as the foundation have been doing a lot of need-based intervention. And today at this forum, I would like to present a case study of one of our project, which is a Dhun project, where we have used music as a therapy for the mental well-being of the inmates. So we have done a small study on the project Dhun, which I would like to share with all the esteemed panel and to share the findings of this. So I will just share my screen of this. So can you all see the screen here?
Yes. Yes.
Yes. So Dhun project we started in 2017, where we have focused on behavioral reformation of prison inmates by using music as a therapy. And for this project, we have collaborated with Sony Pictures Network. And to implement this project, well, we implement this project in 5 prisons, 3 prisons of Haryana and 2 prisons of Uttar Pradesh, where the project has implemented this music as a therapy with 660 inmates over the 2 years. And as I have shared, the baseline assessment revealed that many inmates face serious mental health problems like stress, anxiety, anger, and restlessness. And so the objective of this project was to use music as a therapy to harness positive behavior changes and reduction in recidivism in the inmates. So we did a third-party impact assessment of Dhun project with 101 prison inmates, where 51 were the Dhun participants and the other 50 were the for the control group, which was not a part of Dhun or the music therapy. And the methodology which we used were to evaluate was Fredman Well-Being Scale, to evaluate the well-being of the prison inmates on the 4 parameters of sociability, happiness, emotional stability, and self-esteem. Level service inventory scale to assess the reduction in recidivism in the prison inmates. So the empirical finding was very interested. Though we were seeing the changes ourselves, while our project coordinators and the superintendents which were working with us telling us every day the changes they were seeing in the behavior of the inmates, but then these empirical findings really put figures into it, that the well-being score of Dhun participants was 82% more than the match control group. So we found that the 82% of the Dhun participants' well-being was much higher than the other inmates. And on the other hand, we also find out that the 26% a lower probability of reoffending in comparison to non-Dhun inmates. So this was a very interesting finding which came up, and this was really appreciated by the jail administration also, and has helped us to replicate this music as a therapy in other prisons also. So apart from music as a therapy, we combine this with the individual counseling of the inmates also, which again has given greater positive and behavioral results. And not only the impact was seen in the behavior issues of the inmates, but overall the environment of the prison were also becoming very positive. So these were the imperial findings which we have found it out, and on the basis of this entire study, we have been requesting other superintendents and the other prisons also to replicate music as a therapy, because as I've heard about a lot of people saying, yes, skills is very, very important, but we as India Vision Foundation believe that once the person is mentally prepared and mentally sound, then they will be participate in the skill opportunities which are provided by the prison or the other NGOs very, very actively. So we as an NGO are providing skill opportunities also, but before that, our focus is more of personal counseling with one-on-one counseling with the inmates, so that to understand their need and what are their interest level to learn the skills. And accordingly, we channelizes their energy and we channelizes their interest in the skill programs which we already doing. I also would like to share a few things where one of the speaker was telling the sensitization of prison officers is very, very essential and very, very important when we talk about the reformation of the inmates. And we, since we are working very closely with the prison administration, so we do a lot of training programs specifically on sensitizing the down level warders of the prison, how to value the person, be it an inmate under trial or a convict, as a human being. And all these initiatives with the prison administration has given a very, very good results in the overall reformation of the inmates and increasing the positive environment inside the prison. So this was one of the study which I would like to share. We as India Vision Foundation have ample of studies which I would like to share in future, more academic sessions here with Symbiosis. But here, this is what I would like to present. Thank you so much.
Thank you, ma'am.
Yeah, let's go to the other panelists.
I would like to invite Advocate S.K. Jain, who's a criminal law advocate, to kindly present your views on the theme that we're discussing.
I hope I'm audible.
Yes, sir.
Thanks for giving me the opportunities, Gurupur Madam and Symbiosis. On the basis of my experience, I will share certain thing and I will put forward my views, because all the speaker has given in details, all parts are concerned. Let me tell you, between 1972 to 80, all the bail applications before the sessions courts used to be disposed of on a very day. Even though there was only one session judge dealing with the bail cases for the district and the city. 80 to 90, somewhere it was 2 days, 3 days, it was a panic, but they were there. Now the situation is that months together the bail applications are pending. I am on the point that why prisons are full of under trial prisoners and others are concerned. Now at any level, 1 month, 2 months are there, even though the Supreme Court time and again says that decide the bail applications on the very day, next day, or pass the interim orders, the judges are indifferent. So whether somebody will take up the cause that fix the responsibility, that why this much time is taken to decide the bail applications, whether the judges are indifferent, whether they are overburdened, whether they are not getting the assistance from the bar and the bench, or what is happening, find out the cause. I will give few examples. When we file the bail applications, certainly prosecutors are given notice. After 4 or 5 dates, the judge passes an order that because the investigation is pending, I don't want to exercise the discretions of bail. No, this fact was known on the very first day. Why he should keep so much pending? Means we can find out various examples. And therefore, my First point for the considerations of this August gathering will be that while deciding the bail applications are concerned, whether the responsibility at all levels is to be fixed, that why there is an inordinate delay in deciding the bail applications, so that the under trial prisoners at least will reduce to some extent. I'll go to the second part. Just now I was reading Economic Times, and Supreme Court is going to pass certain directions to decongest the jail in these pandemic situations. Now the question is that Supreme Court is passing the orders, but whether it is percolating to the Sessions Court and the Magistrate Courts, that is the questions again. And if not, then through the Principal District Judge, through the Administrative Judge, through the High Court Judge in charge of that district, the matter has to be examined seriously, and they should be advised. I will say that, I will not say that take actions, but those who are found indifferent, guilty, or could not pass the orders, then they should be advised, they should be trained, and they should be told that why such orders are required to be passed in this present scenario. Even in these cases, when we file the applications in the court, indifferently 10 days, 15 days, 8 days, they are adjourning the matter. Why? And who is going to question them? Are they are not answerable? And therefore, because I had an occasion, I don't know whether Phansalkar Doshi madam is there or not at present. I had an opportunity to appear before her when she was a magistrate, when she was a session judge, and after the High Court also before the arbitration. The efficiency of the judge is an important factor, either to decongest the jail or to fill the jail. That is my first submissions for the considerations of this August. Now the second part comes, that as per the normal norms, a session trial should be completed within 4 days. A trial before the magistrate is to be completed within a day or two. Now suppose that there are 5,000 jail inmates in one jail, and so there may be 1 or 2 or maximum, I will say that 4,000 cases are pending. If we will appoint a special judges who will take it other than the working hours, or during the working hours, the judges who are retired and reappointment and other parts are concerned, and if they take it the matter seriously, the matter can be disposed of within 4 days trial before the Sessions Court, and within 1 day trial before the Magistrate Court, if everything is ready. Keep the property ready if it is required, keep the reports ready if it is required, if the witness is at a long distance, keep the video conference ready. If the advocates are not coming, ask him to make other arrangement, unless that at the 11th hour he is met with accident or ill or whatever it is there. And therefore, if the judiciary decides that we have to deal with the under trial prisoners cases are concerned, it can be finished 1 year. But what is unfortunate, that again I was reading today the journal, and the Supreme Court has passed an order directing an accused to release on bail. Why? That his period as an under trial prisoner is so substantial that even if he would have convicted, that would have been lesser than his. I will say that the Supreme Court has to be praised that they have taken this view. But then I feel and I request that they should find out that why this much time has been taken, what is the cause, and what is the answer to this, and whether this can be done. Because ultimately we find that years together the trials are pending, and the questions will be why. And for that purpose, whatever is there, I am again not blaming one or other, but the questions will be that, is it not that we have to fix the responsibility of all the persons, find out the reasons, the delay in the trial, at least in the case of under trial prisoners, make the special provisions of the special courts, or put it in the additional courts, maybe at magistrate level, maybe at the Sessions Court level or other level. So if we will make this arrangement, because everybody has talked about compensations, no doubt one must get the compensation. But looking to the Indian judicial system in the civil courts, if one files the suit, the poor fellow will not get at least for 5 years or 10 years justice for getting the compensation. So whatever he can get as per the provisions of Criminal Procedure Code, that is there. But even in that cases, judges are not so sensitive in all the cases to give adequate compensations. I will go to the next point so far as these parts are concerned. And again, I will give examples. What has happened in these GST cases? At present, we find that every day there are news in the newspaper, 100 crore scam, 10 crore scam, 15 crore scams. I can give you at least 8 examples in Pune, which I will tell you, that people are arrested. What the officer do, intelligent officer in GST? You pay the money. All right, you pay the money. For that purpose, he arrests. File the bail applications. Invariably, they rejected because of the pressure and all these things, that crore of rupees scam. Then Sessions Court rejected. And then what happens? In all the cases after 2 months, they had been released on bail. What has happened in these 2 months? Why these people have kept for 2 months inside? Who is responsible for this? Or invariably put GST, put crores of rupees, these things, and keep it inside. So there are various cases of that kind. Supreme Court time and again said that even in economic offenses, you examine it, and wherever is possible, you exercise the power of bail. But then the question is that the things are not percolating at the trial court, and therefore these things are happening. So the one cause of full of prisoners, under trial prisoners in the jail, is the indifferent attitude of all the concerned persons while cooperating with the disposal of the matters either at the bail or the untrial prisoners. The second part comes is that what happens to the jail prisoners. In fact, you will find that in jail also so many things happens which is a talk of the town. And that part is concerned, it is not a subject at these junctures. But I will say that even
So sorry to interrupt. I think you have been muted. Could you kindly unmute yourself? Sir, you're still muted. Could you just unmute yourself, please?
Is it no? I'm audible?
Yes, sir. Yes. Thank you.
So I was on the point of advising, guiding as a friend and philosopher to the judges at the trial court level, at the sessions court level, that how the target can be achieved of early trial and early disposal of the cases, maybe bail trial or maybe the court's cases after the charge sheet is filed. That is the one part of it. Then the second part is at the appellate stage, exercising the powers and other parts. Therefore, the sum and substance which I want to present before the August gathering is that if everybody cooperates, bar, bench, investigating officers, staff, by keeping everything ready, then the congestions can be reduced in the jail. I think that the second part is concerned, as it was said by Mr. Upadhyay and others, that there is a difference between the police and the CBI. I had an occasion to consider both the cases. What police do, that they are in a hurry of arresting the accused, and then they will submit the report 169 or anything. In CBI matters are concerned, they are not in hurry to arrest the accused. First, they will collect all the evidence. They will analyze it. And then whatever the period they are getting of this police custody or that part is concerned, they interrogate, and therefore they are getting the better result. So the questions comes that in what manner the police can be guided, again, instructed, trained, that where to arrest and where not to arrest. Because arrest is concerned resulting in curtailing the liberty of the persons. Time and again, the high courts and other courts says that the curtailing the liberty is concerned, it's a crime. But then what it happens to? Whether it is in reality. I will here again cite one case, a small case, because I'm taking 2-3 minutes. It was a case of a fake currency. It was a case of a shop where the shopkeeper received some few fake currency notes, a bundle. He was not knowing, so he sent it to the bank for the purpose of depositing it. The bank manager said that this is a fake, so what is to be done? Shopkeeper said that, sir, if it is there, this has happened. It is my bill and everything. And therefore, kindly do the needful. Bank filed the case. I filed the bail application that, sir, he is a servant. As per his master, this thing. By passing the 15-page orders, the bail application was rejected. And on the next day, the police filed the report under 169 that there is no evidence. Now here the questions come that who will be responsible for this? Whether the arrest by indifferent attitude, whether the attitude of the courts of rejecting the bail applications with indifferent attitude, or the system. So there can be thousands of examples of that kind. And the reason so many, and it is a talk of the town again. So again, the third party comes that at all levels, all the concerned persons, including the advocates, should be trained, advised, and told that at least in case of the under trial prisoners, under trial cases, don't ask for the adjournment. And if they ask for adjournment, there should be a heavy cost for that purpose. I think that I wanted to draw attention on this point. So far as the compensations, filing of cases, other parts are concerned, I was hearing for 1 hour all the speakers, and therefore I don't want to take more time of this August gathering. Thank you very much.
Thank you, sir, for sharing those very pertinent views on under trial cases and circumstances of mismanagement. I would now like to invite Dr. Arvind Tiwari to express your views and deliberations with regard to the theme of the plenary session.
Yeah, thank you. Quickly, I will just place some issues. One is like this DNA evidence, like when we are talking of Innocent project in UK, if you'll see the whole history. And this project has demonstrated that the DNA has helped a lot, particularly in sexual offenses, to prove the innocence or the guilty. And in our country also, some of the states have done it, and it has successfully shown that if the DNA is being done, DNA evidences are taken, and forensic evidences are taken by the police, and these are being properly packed and sent to the forensic science laboratories, and their reports are coming on time, then this is helping the under trial prisoners to prove innocent, or if they are guilty, then it can be proved that they are guilty. However, our condition of our FSLs, etc., is also very poor. If you'll see in Maharashtra and other states, many staff are on contractual basis. Vacancies are not filled. Their remuneration, their career path. I mean, all these things we have to see in a holistic manner, that how we can strengthen the forensic support to the crime investigation, because that could be only the one ray of hope. One of the senior police officer from UP cadre did PhD and then postdoctoral work under my supervision. And POXO cases he has analyzed from Uttar Pradesh and proved that DNA sampling in the cases in which was taken, and it has helped a lot to prove that few people, those who were arrested, were innocent also. So I mean, that could be one way that how we can do it. Another is a provision of this human rights courts. Section 30 of the Protection of Human Rights Act says that every district session court should be designated this. But we do not have procedures, separate procedure and classification of human rights violation. I think that is also because several crimes which are being committed by the state, and the phenomena of after 1970s, that the like state-sponsored violence and the custodial violence. So all these kind of cases, fake encounters, etc., those cases which are being reported, that is also required that these courts, if are set up and functional, and the code is there, then perhaps this can also help to speed up the process. As has been mentioned earlier, the video conferencing facility can also strengthen many in jails. It is not functional, it is not working, or the connection is not good internet connection. Similarly, police escort, as and when it is required, like Andhra Pradesh had the dedicated prison police escort, which is dedicated to the prisons. Similarly, there is a need to have a little more this kind of police escort. One institution which I feel, which is also in the present manual, non-official visitors. You see, they can also help a lot to identify the people, because they can meet the under trial, they can talk to the people, they can understand, and they can report the matter. And there is a provision for in the present manual for appointment of non-official visitors, those who are coming actually from community. But invariably, this institution is also politicized, and most of these people are political. Either they are not appointed or the political appointees. And if this is also strengthened and carefully good people are being appointed, I think they could also help a lot to these people, innocent people, those who are lost in the jail, and they can bring the issues relating to these to the concerned authorities. And as Dr. Sethi has said, mental health, health per se, and mental health, of course, is a gray area. But health also is in very poor state in our Indian jails, and doctors are not willing to go to the jail posting, and there are several issues with that. We don't have much time for that. So there is a need. What I feel, that the prison staff also, the training, some of the speaker has pointed out, the training, remuneration, their promotion policies. If we will also, because sensitization so far, because I have also been working with the prison staff since last 2-3 decades. And you see, there are both kind of scenario. One, yes, corruption of course is there everywhere, so in the prison also. But also there is a cycle of these, that you see, the training, the good training is not there, then the career path is not there to them, the present security is there one way. So there is a need that the staff should also be properly taken care of, and also the vacancy should be filled. And also, because until unless we are not taking care of the staff will not take care of the prisoners. So there is a vicious cycle, that you see, there is a exploitative kind of the whole environment in the prison circle. So I think there is a need to look into holistically the prison training, and the remuneration, and the career path. Some of the, when I have conducted training since last few years back, some of the prison staff from one state, I will not mention, has said कि साहब हमने आके सर हमने आके गलती कर दी कि हम प्रिजन में भर्ती हुए, क्योंकि आज की तारीख में ना तो हमें रिस्पेक्ट अपने परिवार से है, ना हमें समाज से है, क्योंकि people are also feeling that we are also like a criminal. So the question is, the respectability of the prison staff is also not there in the society. And I mean, there are a whole lot of issues. There is a need to look into also the national prison policy. But unfortunately, in our country, I will say that the prisons are, nobody is bothering to improve the prison conditions. The system, the political system, the governments are not seriously interested to improve the system. I think this is a big challenge for all of us, civil society, the academia, and as a society also. This is very important area where we have to work, and we should see that innocent people should not suffer. If they are suffering, they should get the adequate compensation, and also other kind of support system, as has been mentioned by other speakers. Thank you.
Thank you, sir. Thank you for highlighting those areas of prison practices to aid innocent prisoners lingering in the jails, as well as prison staff itself. Thank you for that. I would like to invite Dr. Bhushan Kumar Upadhyay to kindly express your views and your deliberations in regard to this topic.
Okay, thank you, Lasya. Can you hear me?
Yes, sir. You're audible.
Okay, thank you. Actually, it is a very interesting topic, and Dr. Harish Shetty, Jain Sahab, Mr. Tiwari, and Monica Madam, actually they have thrown light on different aspects of the prison administration and bail. Actually, I will try to confine myself to some of the good practices in prison reform, which can be done at the level of the prison staff and NGO. Really, I congratulate Monica Madam for the things which she has done through her NGO. And some of the things which was shown by her are very simple things. They don't need much infrastructure, money, but they need our devotion, commitment, and some empathy for the prison. Daily, I was just glancing through her slides and a screen material. Actually, she mentioned music as a therapy. Really, when I was working as ADG prison in Maharashtra, we started community radio in so many prisons of Maharashtra. And we found that because of that radio, there was lots of positive impact upon the mind of the prisoners. They were operating the radio, they were giving farmaish and choices to the center, and they were listening to them. Therefore, there are lots of things. And Mr. Tiwari has been associated with us for a long time, and he must be remembering, we started one initiative in Maharashtra that is called Gala Bhet. Gala Bhet means embracing one another. And there were lots of resistance from the lower staff, as mentioned by Monica Madam, others. They were telling that, sir, how children of the prisoners can come inside the prison. I told them that what is wrong if the children are coming inside the prison, and if they are spending some time with their parents, and if they are embracing one another, and if it is going to transform the mind of the prisoners, then what is the problem? I will just quote one thing. In Anda cell of Nagpur prison, when I was working as DIG prison in Nagpur, there was one terrorist. He was accused of terrorism, and he was put inside the Anda jail. That is a prison inside prison, because those persons who have visited prison, they must have seen that egg-shaped cell. He was very aggressive, and he was just not being controlled by anybody. When I joined prison department, and when I went to visit the Anda prison, I was suggested by superintendent that, sir, you please don't visit the Anda cell, because there is one prisoner and he always abused all senior officers. I told that, no, in this case, I must visit it, because if I don't visit it, then it will be of no use. Then I went, then he was very abusive and very violent. I told them, don't do anything to him, let him say whatever he's telling. For 5 minutes, he was very violent. But for the first time, he realized that a senior officer was just listening to me. And I asked him that, why you are so violent? What is the problem? He told that, sir, I have got one child who is 8-year-old now. And when I came in the prison, my wife was pregnant. And till now, I have not been able to see my child. If you manage to bring that child before me, I want to hug him. And after that, I will change. Then this matter came to my mind, and we talked to so many persons. I talked to some of the experts. I talked to secretary. And then we started this Gala Bhet. And you will not believe that when the child of that prisoner was brought inside, that prisoner hugged their child. Both of them took food. That prisoner bought so many chocolates, other things from the canteen. And he was totally transformed man. Therefore, in entire Maharashtra, we introduced this Gala Bhet. And because of that, it had tremendous psychological impact upon the prisoners. They became very positive. And they were asking, sir, aap ye phir Gala Bhet kab lene wale hain? So I think it is not going to cost much. It is just our empathy. It is just our innovative idea. Again, we started that video calling in the prison of Maharashtra. Now it has started everywhere. First, we started for the lady prisoners. And there is one separate women prison in Yerwada. We started, and again we found the impact on the mind of their, because they feel connected to their family. Because if they remain connected with their family, then they have hope, and they think that when we come out of the prison, we may be accepted by the family. Therefore, it is also a big thing. And as pointed out by Mr. Harish Sethi, mental health problem is a big problem in prisons. Our men are not aware. So many things are happening inside prison, violence and other things are happening. And the prisoners are doing in a fit of rage, or they have some mental problem because they are traumatized. They have mental illness, they have psychosis, they have neurosis. Therefore, we did one thing with the help of some groups of psychiatrists in Yerwada. We started some self-help groups. Really, some of the educated prisoners, we picked them, and we give them some training, 7 days training, a small training, how to recognize a man, because a man is in a depression, then he develops some symptom, he does not talk to people, he wants to spend his time in isolation, or he becomes very violent. So because with the help of this self-help group, we were able to identify more than 500 prisoners, those who had hidden a psychosis problem. And then we, with the help of these doctors, we started telemedicine also with the Jahangir and other hospital, that government hospital, and we found that it was very helpful. Therefore, all these things are very important, and as pointed out by Mr. Tiwari, that nobody is caring for prison, because prison is a very neglected type of thing, and those officers and men who are working there, they have very low spirit, and the officers who go there on deputation, they think that they are not good person. Therefore, their self-esteem also needs to be boosted. Training should be there. Their other facilities should be there. And I just want to share that during my tenure as ADG prison, we requested the Maharashtra government, and Maharashtra government issued 15 GRs, government resolutions, and lots of things were brought at the priority of the police department. The pay of the Havaldar, the pay of the constable, the pay of jailer, they were brought at parity with police department. The recruitment was also integrated with police department. There was only one recruitment rally, and in the same rally, prisons guards were also recruited. Therefore, I think, in my view, more and more NGOs should be involved in prison work, because I have found that our prison officers, they don't want outside people to come inside. There are so many things which they fear that those things will go outside. But I impaneled so many NGOs, good NGOs, during my time, and they were working. Mr. Tiwari is a witness to it. And I think that if government, NGOs, prison staff, training, judiciary, all they combine together and make a small effort, we shall be able to do a good job. But my concern is arrest. My concern is that only those persons should be arrested who are dangerous to the society. Just because the offense is cognizable, the offense is billable, why a man should be arrested? Because if arrest is not going to serve any purpose, we are criminalizing people. If a man goes to prison, he is totally traumatized, his entire prestige and his honor is destroyed, and for the entire life he carries a stigma. Therefore, why we should send such persons to prison? And if we curtail the power of arrest, if we rationalize the method of arrest, corruptions at pollution level will also come down, because people are afraid of arrest. They think that police will arrest us and send to the jail. If there is some rationalization that in these offenses only cases will be trialed in the court, the person will not be arrested, he will not be sent to jail. After conviction, whatever the court decide that we done, then that is also going to serve the purpose. Therefore, I think all these are very multifaceted things, and those persons who have not worked in the prison department, or those persons who have not seen the prison from inside, they will not be able to understand it, because prison have very long and tall walls and nothing is visible from outside. Thank you.
Thank you, sir. Thank you for your holistic views on the issues that are surrounding innocent prisoners and the role of the police department, but especially your emphasis on the socio-political dimensions of arrest and the, role of the police in that. It's such an insightful addition to the roundtable discussion. Thank you. I would now like to call upon Mr. Sunil Chauhan, Director, NALSA, to express your views and deliberations with regard to the theme of the plenary session, sir.
Good evening to one and all. First of all, I would like to thank Director Ma'am Shashikala ji and the organizers for inviting me and giving me opportunity to share my views. Now, this session pertains to analysis of data, case studies, and good practices. So I'll start with some analysis of data. In a year, around 52 lakh persons are arrested in this country. And if you see the data, how many inmates are admitted in the prisons, the data shows that only 18 lakh prisoners go through the prisons. So what does it indicate? it indicates that only 64% of the prisoners are given bail. They are let on bail, they never enter the prisons. And 36% of the arrested persons only pass through the prisons in a particular year. Now let's analyze the data from some other angle also. If you see the total number of criminal cases pending in the courts at the district level, they are around 2.75 crore, right? And the total number of under trials in the prisons are around 3.30 lakh. So take out the percentage, it will be less than 2%. So if we see the under trials who are in the jails vis-a-vis the total number of criminal trials which are going on in the courts, so the percentage is even less than 2%. It is around 1% only. So now a little bit more analysis of the under trial prisoners also. If you analyze the data of under trial prisoners, you will find that 51% of the under trials have not even completed 1 year in the prisons. And only 18% of the under trials, they are in the prison for more than 1 year. So this analysis, the analysis which was the PPT which was shown in the inaugural session, that reflects the data, the share of the under trials from the prison population. But what I think is this, that these important aspects also need to be included in the analysis. Now, coming to the before coming to the case study, let me analyze the entire scenario from some another perspective. And for that, I'll classify the prisoners into 4 parts. 1, pre-trial prisoners, in whose cases investigations are going on. Police, they still have to file their report under section 173. Second category is under trials, where the in whose case investigation is completed and the report under section 173 CRPC has been filed and the person is facing the trial. And the third is convicts whose appeals or SLPs are pending in the high courts or in the Supreme. And the fourth category, convicts who have exhausted the remedies of appeals and SLP, but they have become eligible for remission. Now coming to the first category, that is pre-trial prisoners. Now what happens that, as I said, that as far as the bail is concerned, it cannot be said that the courts are not liberal. If you see the data, only out of the total criminal trial, only less than 2% of the under trials are inside the jails, one thing, and only 36% of the arrested persons in 1 year pass through the jails. Now, there are certain issues when it comes to pre-trial prisoners. We at NALSA formulated a protocol for providing assistance at early stages of criminal justice. When I say early stages, it means providing of legal assistance at pre-arrest, arrest, and remand stage. Why pre-arrest? Because with the introduction of section 41 capital A, we now have a pre-arrest stage in CRPC. So persons cannot be arrested automatically once the FIR is registered. The procedures spelled out, particularly in offenses which are punishable with punishment of less than 7 years, police has to follow the procedures spelled out in section 41 capital A. Arnesh Kumar Vasti State of Bihar also mandates the same. It has also elaborated section 41 capital A. Now at pre-arrest stage, if a person is called as a suspect to the police station, the problem which we are facing is this, that we do not know whether the person has been called to the police station or not. So in such a scenario, if the person is in need of legal assistance, we are not able to provide. Last year, we provided such legal aid to around 5,600 something suspects. And out of those, what if you see the data, 2,000 suspects were not arrested by the police. Why? Because our lawyer also emphasized there that power to arrest is one thing and justification is another thing. And relevant provisions and the law was also shown to the police. That is one. Now, if you see section 41 capital D, it says that the person arrested has a right to legal assistance. But the entire chapter does not say that the person called to the police station as a suspect also has the right to legal assistance. So there is a legislative gap. So how we have filled that gap? By taking help of the judgment given by the Honorable Supreme Court in Nandani Shatapati way back in 1978 by Justice Krishna. But still, the position is this, that at the early stages of criminal justice, our legal framework is weak in terms of policy also, and in terms of legislation also, and in terms of its implementation framework. Because we do not have a law which says that the investigation cannot start unless and until the police, unless and until the suspect or the arrested person has a lawyer by his side. It only says, as I mentioned, that under section 41 capital A, capital D, police only has to inform that you have a right to legal assistance, and many police officers, police officials even do not know that they have to inform. Now coming to the second, the under trial, where the investigation, where the trial has started and the police has already filed report under section 173 CRPC. In the case of such under trials, what we have seen that that people are not, that the under trials are not aware about the progress of their cases. The lawyers, and there is a communication gap. There is a total disconnect rather between a lawyer who is representing a under trial and that under trial. How the bail application, whether he has filed the bail application or not, under trial does not know. How his case is progressing, whether it is at the evidence stage or at the stage of section 313 CRPC or at argument stage. Most of the under trials do not know this thing. Now we have around 1100 jail legal services clinics, and we do also have our legal aid functionaries also visit jails, and we also do some campaigns also. So this is also our one of the focus area, to make the under trials aware about the progress of their cases, so they know what is happening in their cases. Particularly in case of that is a different point I'll cover later on. And third is convicts who are eligible, whose appeals and SLPs are going on. Now what happens once a matter goes to the High Court? What we have seen that High Court lawyer, whether the lawyer is a legal aid lawyer or a private lawyer, there is a big gap, a communication gap between a convict whose appeal is pending and that lawyer, because information does not flow to the prison about the status of the appeal, how the appeals is progressing, whether the bail application has been filed, whether the application for suspension of sentence has been filed or not. This is a disconnect which we are trying to redress. And in case of convicts who have exhausted the remedies of appeals and SLP, but who have become eligible for remission, recently we conducted All India survey and we found that various states, almost all the states have the remission policies, but all the remission policies are different. In most of the policies, there are no timelines, meaning thereby if a convict has become eligible for remission, then his application can remain pending for infinite period. And in one of the states, what we have noticed that the applications were pending for more than 9 years and even for 10 years. Now, most of the, if we analyzed all the remission policies and we found that the remission process actually does not start immediately on convict becoming eligible for remission. So there are certain suggestions which we have submitted in one of the matters before the Honorable Supreme Court, and most probably a workable and practical things may emerge out. Now, coming to the case study, we organized one campaign for women prisoners and children accompanying them. At a given point of time, around 19,000 women prisoners are there. So in that campaign, that was pan-India campaign, we had one-to-one interaction with 91% of women inmates. And we also, in our teams, doctors were also members of our team. So they, from the medical point of view, from the point of view of the health needs of women prisoners, they took care, and our lawyers took care of the legal needs. So that was a very successful project. For instance, in one of the around 1,600 prisoners, we found that they were suffering from mental illness, and many women prisoners were on the verge of committing suicide. But intervention was made, the treatment was started. And for instance, in one of the cases, women prisoner was under tremendous stress because when she was arrested, she was not told that where her 2 children had been taken. So she was worried that where her 2 children were taken, and we then, traced them out, put them in the children home, and also got them admitted in the school. So these are very, that was a very successful campaign where we took care of, and we also, took help of the NGOs also who and provided vocational training to the women prisoners. That was an instance of access to justice in its expanded form, in its broad vision. So thank you very much.
Thank you, sir. Thank you for sharing your reflections on the statistical data and also the value of pre-arrest and remission as a part of the criminal procedure. I think that's a very interesting addition that you have made. I'd like to invite any responses or reflections from Mr. Srijanpal Singh or Dr. S.E. Raina, sir, to the deliberations that have been made in the second plenary session. All right, I think then we'll move on. There are a few questions in the chat that have been posed by the participants as well. So to moderate the question and answer session and also to deliver the concluding remarks for this plenary session, as well as the overall conclusions, outcomes and resolutions, I would like to call upon Dr. Shashikala Gurpur ma'am again.
Salutes to one and all, to the panelists. Everybody did a great job. It was such a learning for us also, especially with the, with the voluntary organization like India Vision, the research that was brought out in terms of impact analysis was really commendable. Professor Tiwari's observations, Dr. Upadhyaya's, and most of all, our own advocate S.K. Jain's first-hand observations as an advocate shows how there is a fragmented approach. There needs to be better integration of these issues in terms of justice. And also at the end, NALSA reflections with Mr. Sunil Chauhan, who in no way was less than our PhD researcher in terms of those very, very nuances that he brought out. With all of that, we moved to the question answer session. So the message that was very clear was that there are many attempts, best practices, looking at, reducing such overload on the prison, better treatment, etc. The questions have come in the line of, first of all, first question has come in the line of what they think is solitary confinement. That solitary confinement is a heavy toll on the health of the inmates. So the theory of reformation, where one can be reformed or given imprisonment term, even life imprisonment, people are allowed to leave after some time. So the sentence of solitary confinement, why should it be there? Should it be removed? What I think is, I agree with the questioner that civilization has moved forward. We as a democracy have come of maturity. So why should this kind of system be there instead of looking at it in a systematic mental health approach? So question is to Dr. Bhushan Upadhyay sir, or to Advocate S.K. Jain, one of those, or Mr. Tiwari, Professor Tiwari, who comes from the criminology background as well. So one of you could answer this question.
Upadhyay sir, do you want to come in? Please come in, then if time permits, I'll come in. Upadhyay sir. Yeah.
Actually, ma'am, I agree with you, and I agree with the person who has asked the question. Actually, solitary confinement should not be there. For some exigencies and for some of the practical problems, some prisoners may be kept there for some limited time. But as a rule of law, I think it should be there.
Thank you, sir. Tiwari sir, would you like to reflect? Because we have moved forward as a democracy, and why should we have it still? This was Rohit Kulkarni as another question for Mr. Upadhyay as well. But before that, Tiwari sir, I would like to know your view and also Monica's views, because she has worked very closely with 4 or 5 state prisons. Yeah.
Definitely, as Dr. Upadhyay has said, and as we know, the international human rights law and human rights law, national human rights framework, solitary confinement is further criminalizing the person. And as Dr. Upadhyay has also gave the example, I have also seen some of the anda cells in Bombay Central Jail and elsewhere. And really, yes, there is a challenge for the prison officers that some prisoners are really quite aggressive and violent. And perhaps there may be some other way around for them, and they should be treated. But you see, empathy and the compassion is the main source of controlling such kind of people. So I think there is a need that we have to modify the provision in the prison manual for solitary confinement, as well as also we have to humanize the prison administration. But at the same time, the prison staff should also be seen from the human perspective. While we don't have time, Monica is also here. We had several hours of discussions earlier, because you see, many times the deputation, the officers, those who are coming from the police department, with due respect to Upadhyay sir, many times they are not so sensitive, because they see the you see prison from different lens, and because they have been working at the law and order front, so their approach is a little different. Barring few like Dr. Bedi and Dr. Upadhyay and few more very good police officers, those who have really shown that the prisons are the correctional centers. So I think there is a need that we have to revisit the provision in the jail manual, and also to look into the prison policy and the prison personnel perspective. Thank you.
Actually, just one line. Actually, I agree with Mr. Tiwari. When I worked as a police officer, I thought that all the criminals should be inside. But when I was heading prison department, I thought that most of them should be outside.
Yes.
So I think in IPS training, they should be looking at this exposure. Yes. So Monica ma'am, what would be your insight? We would be interested in knowing your insight in this angle.
So ma'am, as rightly said by Tiwari sir, that most of the officers are from different background, and the empathy and the other things are on an overall level is missing. But fortunately, with the prison officers, which India Vision Foundation is working, specifically in Delhi, Haryana and Uttar Pradesh, the superintendents are very, very empathic in nature. And that is why the reason why the foundation could have initiate various intervention programs, need-based intervention program, because of the superintendents and the officers who are in the mindset of reformation. So again, I believe with our experience working in prison that inside prison reformations and the activities solely depends upon the superintendent of the prison who is running the prison. Yeah. If he is in the same mindset as you are, or the empathic in nature, then they will go around like Upadhyay sir said कि एक छोटी सी चीज करने के लिए सिर्फ एक इंटेंशन की जरूरत है. So अगर सुपरिटेंडेंट में इंटेंशन है तो कोई ना कोई रिसोर्सेज हम जैसी NGOs NGOs या और like-minded NGOs मिलकर कुछ ना कुछ कर ही सकते हैं. So I think it's all depend upon when it comes to prison, it's all depend upon the person who runs the prison. Obviously, Director General level तो है, वो एक higher level हो जाता है. But when I talk about the daily 101 programs going on the daily basis inside prison, solely depends upon the superintendents. And I think the training of these superintendents, changing their mindset, showing them good case studies, reformed and rehabilitated, in which really increase their confidence also, and they also try to do something differently in this. So here I just want to add, like, हमारा जो ये धुन project था ma'am, so we in our 25th anniversary silver jubilee, we brought the prisoners, dhun prisoners, outside to our event in in Delhi, and they perform amongst like 650 audience, and the focus was only to sensitize the civil society that there are talents, there are human beings inside prison, and we should see them on that perspective. So, and that happened only because of the superintendent and the Director General Prison of Haryana, who gone out of the way to take the permission. These inmates came out in the police custody along with police, stayed there for the event for 2.5 hours, performed, and that really boosted their morale. They also thought that they think that बहुत सारे inmates ने बोला कि आज लग रहा है कि हम भी इस society के part हैं, और हम जब वापस आएंगे तो लोग हमें accept कर लेंगे. So these are few of the real-time initiatives which has to be taken by the NGOs, and NGOs inside prison can't work without the superintendents or the prison administration. So it's a very close and a very, very, very selective kind of an association. And I think prison officers need a requirement because they have their own challenges, shortage of staff, other things. So I think NGOs plays an important role in fulfilling that gaps.
Yes, madam.
One small point, Professor Gurpur.
Yes.
You see, in 2013, after Nirbhaya case, one documentary was made by BBC. And you see, then I'm telling you the impediment to work in prisons by researchers, by academic institution, is a circular issued by MHA.
Yes.
MHA, which we have also from this side, we have taken up through BPRND. We have in several forums, me and my colleague, we have done some kind of, you see, conversation. But you see, this says that, that this is solely if the good officer is there, permission will be given. If the officer is a little officer, pakka officer type ka hai, then he will say, no, what will be you will be doing and this, that. I am telling you in my experience also visiting the prisons, despite having permission from ADG prison, we were standing on the Yarwada gate for hour together, 1 hour, 2 hours. I said, "Bhai, I have permission. Permission is granted." They said, "नहीं sir, वो अभी देख रहे हैं, आपको बुलाएंगे थोड़ी देर में." So what I am telling you that until or unless, as Monica ji has said very rightly, these the first thing, the MHE should also revisit on that order, and also this order should be revised and sent to all the states, that on case-to-case basis, of course, security is most important for the prison, and all kind of rules and regulations should be followed while visiting the prison. However, you see, this should not be detrimental that if the researchers, if the lawyers, if the NGOs are not allowed to go and do the scoping studies and come up to some kind of support and solution,
yes, sir. Yes,
we cannot improve the conditions. Thank you.
Without research and analytics, how do we go forward? I liked Ms. Monica's observation on bringing the prisons closer to the society by these ways. And instead of ghettoizing them and alienating from the society, how do you, in a kind of very closely, carefully monitored dosages, bring them back to society and the society being open to them? Now here, there is a connected question by the same student, Rohit Kulkarni, where he talks about how do we change the attitude of the society when Advocate S.K. Jain as well as Dr. Upadhyaya and Mr. Chavan, Chavan sir spoke about, you know, the idea of being retributive, that they should go to the prison, that the lawyer who sends to the prison is a good lawyer. If the person got imprisoned, then that is a good law. or that's a good judgment and that's the right justice. So instead of that, understanding that they also have rights and the prison conditions are different, they may need improvement, they're overcrowded. So this kind of bringing the reality closer to the society and making the society look at from the reformist point of view. How do you do such a social conscientization is the question that this student is asking, which is a very good question. That imprisonment-based revenge justice should not be in the mind of the society. Society should be looking at reformist approach. So I am interested in knowing the views of the panel. At least some of you can speak, especially Tiwari sir or Monica ma'am or Bhushan sir.
Yeah, Professor Gurpur, what I feel that you see, we have to open the prison gate for the community also. I mean, selectively, of course. I mean, not like for anybody who can visit there, but there is some restriction, some kind of, because majority of the people, they do not know what is happening inside the walls. Like as Dr. Upadhyay had mentioned, Gala Bet Mulakat. When I have gone along with my students and we have spoken to several prisoners there, they were so happy. कि साहब ने ये कर दिया है, बहुत अच्छा है, at least. Otherwise, you see, mulaqat is a very repressive process in the prison, as we all know. So therefore, there is a need, first thing, that on selective basis, the prison should be open to the community, so community can go and see what is happening. Because there are two kind of scenario. One, many times the repeated offenders, those who are the habitual offenders, and those who are the powerful offenders, they go to the jail and come back quickly, or they are enjoying all kind of facilities in the jail and other prisoners are suffering. So the message which goes to the society through media and other ways is this, that those who are in prison, many times they are enjoying, because you see fans are there and everything is there. So people feel that here are the poor people outside, they are not getting the facilities, and prisoners are giving too many facilities. So there are, contradictory views. There is a need little bit to open the prison gate for the NGOs and the community per se also. And also a little more this literal entry should be there in the jail. From the academics also, those who are from criminology, psychology, from social work background, and they should go there and they should work and a little bit, you see, with the support of the administration. These, so correctional administration and security, these are the two different aspects. And we feel, because the training is still giving emphasis on the custody, on the security. So therefore, we cannot expect everything from the prison staff that they'll be doing. Of course, they'll be facilitator. So I think there is a need that also prison should be little accessible, and also the good story should also come out in the video.
The normalization in terms of meeting family members, especially the couple and all, have shown remarkable behavioral changes, positive changes, and de-escalation of violence in American studies. So are Indian prisons ready for that, to give a quality life to the prisoner, especially the under trials? Because most of them are, I mean, as Shalini ma'am rightly said, they are all presumed to be innocent till they are proved to be guilty. So from this point of view, it's a very valuable point. Let me move to the next question. How effective would be the open prison? This is by Harsha. Open prison system as suggested by Supreme Court in 2017 to prevent overcrowding and strengthen social fabric by mainstreaming estranged individuals who are in conflict with the law. I have a connected observation when our team presented, that there are more than 170 open prison slots and we have only 46 filled. Why this hesitation? Is it because we lack in security? Can't we make use of technology when we have so many ways of surveillance? So, Dr. Upadhyay, could you answer this? Or Advocate Sunil Chauhan, I would love to listen to him because he seems to have deep researchers' insights. So, one of you, please, and even the views of Mrs. Monica and Dr. Tiwari. Please, quickly. In 1 or 2 lines, if you could give your views, it would be helpful to the student, please. Why not utilize all the slots of open prison?
Can I come in, Professor Gupta, or Dr.
Yes,
Upadhyay? Do you like to come?
Please, as you are the
Dr. Upadhyay, please.
Is Actually, this open prison concept is a fantastic concept. And Maharashtra, I will quote Maharashtra. Maharashtra has taken a lead in that, and lots of open prisons have been established. But it is also true that lots of slots are not filled up because so many problems and so many technical things. But if the open prison is there, and if the number of vacancies there, that must be filled up, and more open prisons should be there, because in our prison system, more than 90% inmates, they don't have any criminal background. Only 10% are habitual hardened criminal. Majority of them have no criminal background, and if most of them are going on payroll and furlough, they are not violating, they are going on payroll, furlough, they are coming back. Therefore, if they go to open prison, I think it will help the administration. It will help in better prison management, better connect between people and prisoners, and it will be a good step in the prison reform field.
Thank you. So, Monica, would you like to have a quick one or two sentence, and then Dr. Tiwari, and then we move to
so, ma'am, I think the open prison is again, we should try this because this is a very, very good concept for rehabilitation. And when we talk about that, how they will get reintegrated back into the society. So, because we also believe that readiness for release should start within from the prison itself. We are all talking about rehabilitation and reintegrate, but are we preparing the inmates while they are inside and ready, making them ready to go out? Similarly, their family members, are they able to accept them? So open jail concept will really help into this connection of the inmate while they're inside and with their family, and help the society to help them in rehabilitation. So I think more of the effort should be done towards this open jail concept.
Thank you.
Professor Gurpur, three more quick points. I did PhD on open jails in late 80s. And till then, I am also connected with that. I would like to just submit 2-3 points on this. One is this, that the status of open jail in different parts of the country, like in some states, they are having the status of central jail. Some states, they are having the status of the district jail. Some of the open camp, like you will find 2-3 kind of open jail. But open jail, one thing we should understand, only the prisoners, those who are convicted, can be sent, number one. Hold in the central jail. Those who have served there more than 2/3 of sentence, more than half sentence, and with a good behavior, only those are considered with the background that police verification is asked from their residents, that they should not escape. But if we see the data, that the escape rate from open jail is more than the, from enclosed jail, escape rate is more than the closed jail, open jail. So why it is contradictory? Because first thing, apathy from the staff itself. Many staff, those who are posted in the open jail and having the status of central jail, they don't want to go there. Because there are then again reasons, several, I don't want to point out those reasons now. So number one is this. Number two, these committees are not meeting on time. And number three, the prisoners are not being motivated that they should go to the jails. And because you see, after 1978, it has been said that the lifers should serve at least the 14 years of the actual imprisonment. Earlier, the remission in the open jail was a double remission. So if somebody's sentence is left out for 6 years, the person will be released within 3 years in the open jail. Double remission was there. So I think there is a need to revisit these rules, and even for those convicted prisoners, along with the the short-term convicted prisoner can also be considered. And Rajasthan model is the best model in the country, where the prisoners are staying with their families, and they are going to work in the local towns without watch and ward, and the escape rate is very, very negligible. So I think open jail we have to encourage, but also we have to visit these rules in the jail manual, and also prison officers should be held responsible that why the vacancies are there of the inmates, and the other prisons are crowded and flooded with the prisoners, those who are convicted in the central jails.
Thank you, sir. Before we proceed to conclude the proceedings, I would like to invite the panel's attention, particularly of Ms. Monica, to a question from one of my colleagues, Dr. Vivek Nemani. He says, thank you, Monica, for the information on the project of India Vision Foundation. Now, this is a very important question he's asking, which could be one of the proposals at the end of this proceeding. He says, are there any efforts towards establishing peer group networks through which prisoners or exonerees are advocating others based on their own experience in tackling or coming out of the problems they faced? Considering this as a problem around the world in many countries where prisoners experience trauma, I think with the help of digital technology, such positive stories and advocacy through digital peer group networks may prove useful. Has there been any experiment of this sort, either through your organization or otherwise?
Yes, so to address this question, yes, we have already the concept of peer group training. So where we identify the inmates with the qualities like leadership, responsibility, and make them peer leaders. So we call them peer leaders. And we have ourselves notice that these peer groups leaders are the change maker themselves while they are inside the prison, and also once they are released act as a catalyst for other inmates also. Here I would like to quote an example, like in the case of pandemic, where last year when the COVID happened, and unfortunately randomly we were also not allowed to go inside the prison. So with the help of the superintendent, we had a virtual meeting with the peer groups identified and made in the prison through the superintendent, and then we groomed them and trained them in the absence of our project coordinator, how they can continue the work inside the prison. So this is the way how we are making the prisoners and the prison administration self-sustained, because how long an NGO can work regularly inside the prison. So it's good to have the inmates, specifically the convicts, but also the under trials who are there for a longer period of time, can become and are becoming the peer leaders for the various activities or the initiatives which we are already doing. And also when it comes to rehabilitation, we consider these peer leaders when they are out, and we advise and we recommend their names to our known people to give them either a job opportunity or engage them in some or the other way. So we already here would like to share this. In India Vision Foundation, we ourselves have employed 2 of such kind of peer leaders, which we have identified inside prison while working in the prison. One was the convict and the other one was the under trial. And we in our team of prison, we have these 2 people who are now working as an assistant manager in India Vision Foundation prison program, and one as a project coordinator, and they act as a role model. So I can tell you that while they go inside the prison, they are like success case stories, and they like when they talk to the inmate and say कि हम भी आपके जैसे ही थे और आज हमें opportunity मिली है और लोगों को बदलने के लिए. So that's how they become the change agents. So this is a workable model, and I believe we as India Vision Foundation always encourage superintendents to please identify such kind of a peer leaders. We do the homework for them, and then they can act as a catalyst for them. So this is a totally workable model.
Great. Thank you. So that speaks of the authenticity. Now I request our colleague Atmaram Shelke, who is our associate professor, who has done a lot of work behind this whole successful project, to come and give his notes as comments, please. Meanwhile, would Advocate Sunil Chauhan, the Chief of NALSA, like to intervene, sir? You have such sharp...
Ma'am, actually, there is one more thing as far as under trials are concerned.
Right.
We need to strengthen the, we need to translate chapter 21 capital A, that is chapter pertaining to plea bargaining, into action.
Yeah.
For instance, that chapter came into force in July 2006. Even after 14 years, if you see the data, it seems that even after 14 years of incorporation of the plea bargaining, the number of cases which are disposed of through plea bargaining are significantly less. For instance, ma'am, I was just examining data for the last 5 years. In the 5 years, total number of criminal cases disposed of by the courts in India is 3.37 crores cases were disposed of. And out of those, only 80,000 cases were disposed of through plea bargaining. Now, from that means that even less than 1% of the cases have been disposed of in the last 5 years through plea bargaining. Why this is so, ma'am? This is so because if you see this chapter 21 capital A, there is one section 265 capital C. The procedure spelled out under section 265 capital C requires active participation of judicial officers during mutually satisfactory disposition proceedings. So this process may require multiple sessions and eventually consume significant amount of judicial time and resources. For instance, hypothetically, if on an average, one case requires 3 sittings of 1 hour each, the total judicial time consumed in 1,000 such cases would be 3,000 hours. So what I'm suggesting is this, that to make this plea bargaining more practical and to implement it on large scale, we must give this function provided under section 265 capital C to the mediation centers, meaning thereby that the cases which are identified for plea bargaining, those should be transferred for working out the mutually satisfactory dispositions to the legal services authorities to get the amicable settlement in the mediation centers. So this
excellent suggestion. So here there is another suggestion which Mr. Nasruddin Lohar has given to consider inviting senior officers from prison cadre. I think you are one of the exceptions, Mr. Lohar. We have always taken care to see that they are engaged, but most of the time they avoid such fora because of many reasons which all of us are aware of. But if you are willing, we will involve you when we conduct next. Today itself, you have made significant contribution and thank you for that. So in the light of the reforms that we have sent to the Ministry of Home Affairs, as part of criminal justice reforms also, my colleague Dr. Shelke played a key role, which we captured in our position PowerPoint. Now I would like Dr. Shelke to come in and make some observations, and then we move to the summary of today's outcome. Yeah, please.
Okay, thank you, ma'am. The deliberation of today's discussion shows that reformation are required at 4 different levels. First is at arrest level, and 41 clause number 2 shall be taken seriously. So I'll little bit speak about that. Second is at the stage of custody. That person is produced before the court of law and bail may not be granted, may not be granted. Third is at the level of during custody. And fourth is after the duration of the custody. So at the time of arrest, we have to shift our attention from subjective satisfaction of the officer to the objective justification for the arrest. And that objective justification has been already given under 41 clause 2. And Upadhyay sir has mentioned about it, that there may be problem with the investigation. There is possibility of tempering of evidences. There is possibility of doing further offense, or there is possibility of induction, threat, etc. Or there is possibility that person may not be produced before the court of law. All these things are not reflected expressly in the report provided by the police officer while arresting the person. So we have to give thought on that, and it shall be made compulsory and it shall be scrutinized by the court. 2, at the time of granting or not granting the bail. So first question with respect to that is how to decide the bail amount, whether it shall be decided randomly or whether there shall be some justification in the light of Article 14 and 21, whether there shall be some rational basis or whether it shall be random. If it is random, then second question will be whether justice is subject to economical capacity of the person. That question we need to be addressed. And we have the jurisprudence of Article 14 and 21. Now every process shall be due process, and in order to observe the due process, compensation shall be due. That shall be based on the capacity of the person who is going to pay the compensation. Similar rule shall be applied to the bail amount also. Third observation is about the during the custody. Now Shalini ma'am has mentioned about that, but during custody, even 10 to 15% people are released for 10 days, 15 days, etc. That will reduce the burden of the prison. Now, in that, madam has mentioned that there is possibility that these people may not come back, the prisoners may not come back. Now that is the exceptional situation because many people are political leaders, they are in the public work, there are social workers, there are people working with the institution, they are employed somewhere, and therefore it is easy to catch this kind of the people. They may be released for some time during the custody also. And most important point and last point from my side is after the duration of custody. Normally custody is granted for 2 months, 3 months, but after duration, there is automatic extension of the remand that need to be stopped. And there shall be either alert in case of destroying of evidences, etc., or there shall be the automatic bail provision in the law. So person shall be released automatically. Apart from that, right now we are celebrating e-portal for the court system, but there is no mention of the prison system, or it is not yet considered as part of the court system. And therefore, we have to take help of e-portal, that is technology on one side, and there shall be strong monitoring mechanism, and there shall be some provision of the fixing of the liability, as Advocate S.K. Jain has stated. Thank you. Over to Madam.
Thank you, Professor Shelke. Those are very sharp observations, particularly from the law point of view. But overall criminal administration, justice administration system with prison as one of its parts needs to have deeper nuances of social work, therapy, mental health, and all of them. So from that point of view, I think prison administration as such needs to be given more attention, and criminal justice administration system needs to be given better attention. Probably experts like Professor Tiwari and practitioners like Advocate Chauhan, Advocate S.K. Jain, who are senior practitioners, Ms. Monica, Dr. Bhushan could really pave the way for such wholesome reforms. So as we conclude today's panel discussion, almost 1.5 hours beyond the schedule, although let us say half an hour we can give, but 1 hour beyond the schedule, it has been a very, very enriching, fruitful discussion. I'm sure our students have been inspired who have been in the audience. We have had a very promising young officer like Mr. Lohar and activists like Mr. Srijan helping us in bringing this together along with the team of faculty. Now, the overall summary could be quickly captured in 4 or 5 key phrases. One is in terms of project innocence. So how do we have overall system reform from the duty point of view from the state and rights, citizens' rights point of view, within the scheme of overall justice administration system, this project innocence as a combination of policy, law, and rules and execution. That's one. Second important reform is in terms of better coordination between different fragments of the criminal justice administration system. Very important. Third is social awareness that imprisonment is not the best justice, that we as a democracy have come of maturity. Let's shed our retributive approach to justice. Let's move on to the reformative approach. Because finally to that, every prisoner, each one of us is responsible. If we were sensitive to them, they wouldn't have been there. Or if our system was equally supportive of them, they also would have been roaming around in the society like many who could afford the Jetmalanis and Salves. So that reality, you know, in terms of what Chauhan sir pointed out and Bhushan sir pointed out, good legal aid, quality of legal services. So we have already enlisted, and Dr. Shelke also added some points, so that those enlisted points will be further enriched by what came out today with the solid legal structure that Justice Fansalkar ma'am laid out. Now, I have one little concern to add on the plea bargaining, which Chauhan sir pointed out, and he also gave a reformist angle to that, that mediation cells, mediation organ, now specialized mediation lawyers are coming up. Even law schools can aid there. So some of our teachers sit as panelists in Lok Adalat. So why not have such extended to prisons? My only concern is what Justice Lokur once told me. Easy to say plea bargaining, but then are we combining probation with it? Are we looking at getting them out of that mental impact that it may have. So plea bargaining is not just as a device, but also as an impacting mechanism for human side of these prisoners is to be carefully managed with the panel of interdisciplinary experts. So with all of this, if we can conclude successfully that today's reforms will be taken further to work out a kind of elaborate agenda with all of you on board. We request all of you to help us as we go forward. And the important research of Dr. Tiwari to be brought in, the filling of those slots which are available in open air prisons, better management of these prisons. He said sometimes the lists are not even looked into, meetings don't happen, which is a very important point. So such reforms to be added to this in order to strengthen this project Innocent. So let's look at the India project Innocent. So that is a conclusion. So with that, I hand over back to the compeer.
Thank you,
Professor Lasya, and thank you one and all the panelists as well as our esteemed team members for everything that you have done behind the curtains and the participants.
Thank you, ma'am. Thank you for succinctly summarizing the detailed deliberations that have taken place over the 2 successful and important plenary sessions that we've had today. Now, to deliver the vote of thanks, I would like to invite Professor Kshitij Naikade, Assistant Professor and Deputy Director, Administration, Symbiosis Law School, Pune.
Good evening, everyone. Am I audible, Lasya?
Yes, you are.
Okay.
Yes, yes.
Okay, as we come to the end of this extremely professionally organized one-day law and policy roundtable discussion on delayed justice to prisoners in India, it's a pleasure and honor for me to propose this vote of thanks. Although, as ma'am rightly pointed out, we are running late by almost an hour and a half. It is very important for me to kind of propose this vote of thanks and kind of express my gratitude towards the few people who have been responsible for making this particular event successful. For me personally, who comes from a non-law background, this one-day conference really opened my mind space to various issues. Listening to these stalwarts today was like reading a multiple dozen odd books at the same time. And I'm very fortunate to have been a part of this academic gathering. I'm sure the sentiment is shared by one and all, including the students and the faculty who were a part of it since afternoon. This event would not have been complete without me thanking Dr. Mujumdar sir, who's been like the guiding light behind all our initiatives at Symbiosis Law School, Pune, and in the university, who personally graced the occasion for the inaugural today morning in spite of his busy schedule. I want to thank the panelists, both in the first session and this one, who spared time from their extremely busy schedules and participated enthusiastically in answering all the questions that were thrown at them. And I think it was really amazing, whether it is Dr. Arvind Tiwari sir, S.K. Jain sir, Bhushan Kumar Upadhyay sir, or our personal favorite Harish Shetty sir, who also came in briefly, Sunil Chauhan sir, Monica Dhawan ma'am, S.C. Raina sir, who has had a long association with Symbiosis Law School, Pune, Srijan Pal Singh sir, Anirban Chakravarti sir, and all the other panelists who were kind of enthusiastically participated in it. I want to thank them all for making time for this extremely academically rigorous event. I want to personally thank Dr. Gurpur ma'am for being the force behind all these academic activities at SLS Pune for all these years. She's a leader of the highest order, and she proves her mettle as an unparalleled visionary every single time she kind of throws an idea towards us. There's this one Sanskrit shlok, I hope I'm not taking a lot of time, which I want to kind of recite and not just for her, but also for all the panelists from the Upanishads, which I would like to dedicate to her. The shlok is about Kaka Krishna, Pika Krishna ko bheda, Pika Kaya. Vasantamaste prapte Kaka, Pika Pika. Basically, it means that a crow as well as a cuckoo both are black in color. So what differentiates them? What is the most important differentiating factor between them? It is the season of spring. So when springs come, very easily you can differentiate between a cuckoo and a crow. Similarly, there are multiple people around who kind of boast themselves as leaders, as visionaries, but only when it comes to such occasions, such ideas, such thought-provoking conferences that are actually organized, where people real metal actually is kind of proven and comes through. And this is where I think Dr. Gurpur every time proves the fact that she is a visionary, an unparalleled visionary when it comes to events like these. I want to finally thank the core committee, core faculty team who managed to put together this conference successfully. and has worked extremely hard behind the curtains tirelessly to coordinate this event with our distinguished guests. Firstly, Dr. Atmaram Sheikhe sir, Chaitali Deshmukh ma'am, Advocate Samramjit Chauhan, and finally, without whom this event would not have been possible, Miss Aditi Mane ma'am, who I cannot thank enough. I would also like to specifically thank Professor Lasya for comparing this event and patiently coordinating this wonderful event for the past 5+ hours. Thank you very much, one and all. I would also like to finally thank the IT team who has been handling multiple events and responsibilities in this pandemic by coordinating the online lectures, guests, the various guests, coordinating with them, and the various multiple online platforms. So without whom these events would not be possible. Finally, I'd like to thank the audience and the questions that were actually thrown at these distinguished guests, which were extremely thought-provoking and opened multiple ideas for all of us. On this particular note, I would like to probably announce and conclude this event. Thank you, one and all.
Thank you, sir. With this, we come to the end of today's program, the one-day roundtable on the issues of justice, and very specifically what we have discussed today is the delayed justice to prisoners in India issues and challenges. Thank you all for being a part of it. All the participants may feel free to exit the link now. Thank you.
Once again, thank you,
Ma'am,
and all of you have done a great job. Thank you. Thank you for your time and effort.